he stated the following.
Pagka bumunot, patayin mo. Pag hindi bumunot, patayin mo rin. Oh. Para matapos na. Kaysa mawala pa bro. Ako na ang bahala sa inyo. Itaga ninyo ito sa puso ninyo. For as long as I am the president, nobody but nobody, no military man or policeman will go to prison because they perform their duties well. Ako ang mapakulong sa ito. Sabihin mo lang, utos ni Mayor yun.
So that was Mr. Duterte's message to the military and to the police. Kill, whether or not your target pulls a gun, and I will protect you. And Your Honours, as we will now hear, during the same speech, in case there was any doubts, Mr. Duterte made it very clear that this promise of protection related not only to lawful killings.
For as long as there is that power to pardon sa Konstitusyon, yan ang weapon ko against crime. Magmasakir kayo ng 100, di ba? 100 rin kayo, edi pardon lahat eh. Restored to full political and civil rights plus a promotion to both. Problema niya ay yung mayor ng Albuera. Mabuti, nakaabot siya doon kay Bato na pinahanap ko, shoot on sight. Parang aso. Eh, ang tingin ko talaga sa inyo, kayo, parang aso. Tatawagin ko yung mga mayors, ilak ko, no, kami-kami lang. Sabihin ko talaga sa kanila. Ayun, ganong kakapal yung pinakita ko sa inyo eh. Hanapin mo yung pangalan mo dyan, mayor. Pag nandyan yung pangalan mo, may problema. Talagang papatayin kita.
Let's play the video.
Wala akong ako talaga ang walang akong maipagyabang. Kaya ginadaan ko na lang sa extrajudicial killing.
Please play the clip.
Ako po'y galit. Pati yung mga pulis dito sa Maynila nakasabit sa droga. Ako po'y nakikiusap, wag ho kayong pumasok dyan kasi papatayin ko talaga kayo.
4-7.
Yung namatay daw kanina sa Bulacan, 32, in a massive raid. Ganda yun. Makapatay lang tayo ng another 32 every day, then maybe we can reduce the what ails this country.
Now.
Ay, yung mga adik ho dyan, kayo na lang ho ang pumatay. Kung anak niya, ikaw ang pumatay. Kung anak niyang adik, kayo ang pumatay para hindi masyado masakit.
Let's play that clip.
Sabihin ko sa inyo, itong mga panahon nitong mga araw na dadating, kung may punerarya ho kayo, kikita kayo ng husto. Tayo ko yung mga small time na punerarya dito, doon. At sigurado hindi kayo malugi. At pag humihina na ang negosyo ninyo, sabihin ko lang sa mga pulis, bilis-bilisan ninyo ng konti para kumita yung tao sa negosyo nila. Ayan, sinasabi ko na sa inyo.
Ikalawang sesyon na ng confirmation hearing kay dating Pangulong Rodrigo Duterte. Alamin po natin ang nangyayari doon ngayon. Live mula sa The Hague, Netherlands. Nasa frontline na balitang yan si News 5 anchor Angela Lagunzad Castro. Angela, sinong panig naman ang nagsasalita sa ikalawang sesyon ngayon?
Julius, sa aking pag-alis kanina, prosecution pa rin ang naglalahad ng mga ebidensya tungkol nga dito sa confirmation of charges si Pangulong Rodrigo Duterte. At isa sa mga highlights kasi ang key highlights nga ng presentation today ng prosecution ay mga videos and audio presentations na mula mismo sa kay Duterte. Kumbaga si Duterte ang nilalaman nitong mga videos na ito. So pinakita dito sa korte yung paglabas si dating Pangulong Rodrigo Duterte ng photo gallery na naglalaman ng mga individual na kumbaga sabi nga nila high value target. At sinabi ng prosecution kapag ikaw ay nandoon sa listahan na yon ay karaniwan namamatay. So binanggit nila yung pagkakataon na isang high profile case na namatay na nandoon sa photo gallery na yon tulad na lamang nitong si Albuera Leyte Mayor Rolando Espinosa Jr. Namatay siya, siya ay naunang sumuko pero napatay sa loob ng kanyang selda kasama ang isang Raulya. At of course, sa opisyal na ulat, sinabi shootout daw yun, Pero lumitaw sa ebidensya na sinadya silang pinatay sa isang multi-agency coordinated operations, So ilang ulit pinakita ng prosekusyon ng iba't ibang mga videos, katulad na lamang ng pagsabi ni former President Rodrigo Duterte na kapag nanlaban, barilin ninyo. Kapag hindi bumunot ng baril, barilin nyo pa rin. So, ilan lamang yan dun sa mga videos na ipinapakita dito ng prosecution para idiin mismo si Pangulong Rodrigo Duterte sa mga kaso niya. Julius.
Maraming salamat, Angela Lagunsad Castro.
Bago pa man ilatag ang mga dagdag na ebidensya tungkol sa Duterte drug war, una nang hinimay ng prosekusyon ang mga patayan sa Davao City noong mayor pa si dating Pangulong Rodrigo Duterte.
Ipinarinig sa korte ang mga pagmumura ni Duterte sa ICC at ang pag-utos niya noon na pumatay. Ayon sa prosekusyon, si Duterte ang kumumpas sa Davao Death Squad o DDS. At live mula sa The Hague, Netherlands, nasa frontline ng balitang yan si Angela Lagunsad Castro. Angela, ano-ano na ang mga bagong tinalakay ng prosecution dyan?
Cheryl and Julius, tama kayo, nandito pa rin ako dito sa area ng Media Center ng ICC sa The Hague, Netherlands, kung saan ongoing po ngayon yung second day ng hearing or confirmation ng charges ni Pangulong Rodrigo Duterte. Dito inilahad muli ng prosekusyon ng iba't ibang mga ebidensya para magpatibay doon sa kanilang kaso laban kay Pangulong Rodrigo Duterte. At dito nga binanggit nila kung ano yung Oplan barrel project ng PNP during the Duterte administration. Nabanggit din nila yung narco list or so-called PRRD list at mamaya hima-himayin natin yan maya-maya lamang at kahapon nga inilatag ng prosekusyon ng ilang ebidensya laban kay Duterte kabilang ang Davao Death Squad.
May pakita ni Esa Rosales. Karata. Kawan lang. Sabihin nila na yun. Karata. Karata. Tulog. Tanong reaksyon sa mga tao.
Kahapon, inilatag ng prosekusyon ang ilang ebidensya laban kay Duterte kabilang ang Davao Death Squad. Ipinanood sa confirmation hearing ang CCTV ng pagpatay sa 3 hinihinalang magnanakaw sa Agdao Public Market sa Davao City sa katirikan ng araw noong December 2013. Maririnig sa background sinooy Davao City Mayor Rodrigo Duterte. Ayon kay ICC Senior Trial Lawyer Julian Nichols, 3 hitman ng Davao Death Squad o DDS ang nagtumba sa mga umano'y magnanakaw. Sa structure ng DDS, pinakamataas daw si dating Pangulong Duterte na siyang naguutos at nag-a-approve ng mga pagpatay. Iniuutos naman ito ng kanyang co-perpetrators o kasabwat sa DDS handler hanggang sa umabot sa mga hitman.
DDS members did not fear punishment because they were committed at Mr. Duterte's orders or direction.
Nagpresenta rin ang prosekusyon ng mga video at pahayag noon ni Duterte na inamin niyang mayroon ngang Davao Death Squad kabilang na ang pag-amin niya noon under oath sa Senate Blue Ribbon Committee.
So that is 4 times, 3 of them under oath, that he admitted having a death squad in Davao, including saying he is the death squad. That's not hyperbole. That's not bluster. That's him telling the truth, and he feels safe.
Binanggit din ng prosekusyon ng co-perpetrators o kasabwat ni Duterte, kasama sina Senator Bato de la Rosa, Senator Bongo, dating Justice Secretary Vitaliano Aguirre II, dating Davao City Police Chief Vicente Danao at dating NBI Chief Dante Gueran. Ipinakita rin ang lumang larawan ni Duterte na may hawak na assault rifle. Kasama niya rin si de la Rosa na kalaunay naging PNP Chief at si Isidro La Peña na itinalaga noon ni Duterte bilang Director ng Philippine Drug Enforcement Agency o PDEA. Patunay raw ang litrato na tough guy ang gustong ipakitang imahe ni Duterte. Nang mahalal na Pangulo, ginawa raw nationwide ni Duterte ang operasyon ng Davao Death Squad. Nabanggit na raw noon ni Duterte na siya ang aako ng responsibilidad sa madugong drug war.
That's the man before you for this hearing, even if he's not in court today. He repeatedly promised to kill people, his own people, if elected president. He said it, he did it, that's who he is.
Ilang araw bago maaresto, nakuha pa nga raw murahin ng dating Pangulo ang ICC, pero pagdating sa The Hague,
Of course, after arriving in the Hague, his lawyers very soon began arguing that Mr. Duterte was not fit enough for these proceedings.
biglang hindi na raw fit to stand trial si Digong kahit na napatunayan ng mga medical expert ng ICC na physically at mentally fit ang dating Pangulo. Bago ang presentasyon ng prosekusyon, giniit ng abogado ni Duterte na si Attorney Nicholas Kaufman na totoong hindi fit to stand trial si Duterte. Apela ni Kaufman sa ICC, ibasura ang mga alegasyon dahil wala niya itong sapat na ebidensya at bunga lang ng pamumulitika.
We will ask you to send Rodrigo Duterte back to his family, and we will ask you to give back to the Filipino people their Tatay Digong.
So dito nga sa ongoing na day 2 no ng confirmation of charges ni Pangulong Rodrigo Duterte ay pinupunto ng prosekusyon yung direct involvement ni dating Pangulong Rodrigo Duterte dito sa narco list o yung so-called PRRD list no at ipinakita nila ang isang video na nagsasabi nga no and I quote, the one reading, sabi niya, the sole responsible, a sole person responsible. No, sa pamamagitan ng video na ito, si Pangulong Rodrigo Duterte ang nagsasabi noon at claiming na siya ay responsable doon sa narco list. Dito sa list na ito, pinakita ang isang Excel spreadsheet na may mga photo ng mga ilang mga individual na may pangalan, kung saan man sila region, no, kinabibilangan at bawat pangalan doon, Cheryl and Julius, ay may naka-assign na difficulty level or different level rather. No? Una, yung mga lower level lamang na mga police or street level users, yung mga pag nasa 5 level ka na o 5th level ka na, high value target naman ang mga nandoon, ano, yung mga tulad ng drug financiers, mga high ranking police officials. So sabi daw ng insider ng witness ng prosekusyon, ang itong list na ito ay ginagamit ng mga police kung nasa listahan ka, subject ka, or most of the time, kasama ka sa papatayin. Julius and Cheryl.
Angela, matapos nga itong unang araw ng confirmation hearing ni former President Duterte, may balita na ba tayo tungkol sa kanya? Meron na bang nakakausap sa kanya or mismong yung kanyang lawyer na si Attorney Kaufman?
Yeah, Cheryl, kanina no, we were able to talk to Attorney Kaufman sa labas dito bago siya pumasok sa ICC court. Na-ambush interview natin siya at tinanong nga natin siya kung nakausap ba niya si Pangulong Rodrigo Duterte pagkatapos ng confirmation of charges kahapon. Sabi niya, oo naman daw. Nagbigay siya ng update at tinanong natin kung ano naman ang naging kumbaga pahayag ni Pangulo. Ang maikli lamang yung sinabi ni Kaufman dito, ang sinabi niya, he is happy. When we pressed na anong klaseng happy, bakit happy, ganito, sabi niya client lawyer privilege na lang ang sinabi niya sa atin. But he made sure na sinabi nga niya sa atin na nagkausap sila ni President Rodrigo Duterte.
Angela, meron na bang ine-expect na ipipresent na testigo ngayon ang prosekusyon?
Cheryl, kasi nga dahil hindi pa ito ang actual na trial, this is just a pre-trial. Pagdedetermina kung meron bang sapat na ebidensya ang prosecution para i-move forward sa full trial itong kaso. So wala muna tayong makikitang mga witnesses, live witnesses dito. Meron ipepresenta ang prosecution ng mga dokumento, audio and video presentation, pero walang mismong witness. Tapos pinagbawal din according sa House rules ng pre-trial chamber. Kahapon sinabi yan, bawal din magbanggit ng mga pangalan ng witnesses, bawal divulge yung kanilang mga identity. Kung kinakailangan ito sa pagpresenta, ito ay pag-uusapan muna in a private session. Doon pagdedesisyonan kung pwede ngang sabihin during the hearing. Pero so far, yun lang po, wala tayong aasahan na live witness na ipepresenta ng prosecution dito nga sa ongoing na confirmation of charges. Cheryl.
Angela, kahapon nakita natin na in-establish ng prosecution yung sinasabing systematic at organized na mga patayan ng mayor pa ng Davao City si dating Pangulong Duterte. Ngayon ba ay may mga ipepresent pa sila mga karagdagang ebidensya na magpapatibay dito para matalakay na rin kung sino yung mga co-perpetrators o kasabwat daw ng Duterte drug war?
Yun, Julius, yung mga pinapakita ngayon kasalukuyan ng prosecution sa confirmation of charges dito sa ICC court, a pre-trial chamber, yung mga memorandum about oplan na double barrel, itong mga so-called narco list, yan yung mga sinasabi ng prosecution dito kasi sa ICC, Julius and Cheryl, may different modes sila ng criminal liability, sinasabi dito, it's either your direct perpetrator or indirect perpetrator. Ang pinupunto ng prosecution dito ay yung pagiging indirect perpetrator ni Pangulong Rodrigo Duterte na merong mental involvement si Pangulong Rodrigo Duterte. Hindi man siya ang humawak ng baril para patayin ang isang individual, pero siya mismo ang nag-utos at may kinalaman dito sa tinatawag nga nila na war on drugs. So yun yung ilang mga ebidensya na ipinipresenta ngayon kasalukuyan dito sa confirmation of charges.
Maraming salamat, Angela Lagunzad Castro, live mula sa The Hague, Netherlands.
Inisa-isa ng prosecution sa confirmation of charges hearing ni dating Pangulong Duterte ang mga kasabwat umano ng dating Pangulo. Kabilang po dyan si Senador Bato de la Rosa at Senator Bongo. At live mula sa Senado, nauna sa balita si Camille Samonte. Camille, anong reaksyon ng mga nabanggit sa pagdinig?
Bok, nakipag-ugnayan tayo dun sa 5 co-perpetrators umano ni dating Pangulong Rodrigo Duterte para sa kasong Crimes Against Humanity na binanggit sa confirmation of charges hearing kahapon. Tanging si Senator Bongo lang ang sumagot sa isang ambush interview kanina. Naging matipid ang sagot ng senador. Tumagi siyang magkomento at ang sinabi niya lang ay hintayin na lamang daw munang matapos itong confirmation of charges hearing ni dating Pangulo ngayong linggo. Pakinggan natin ang pahayag ng senador.
Same statement po ako. Same statement po.
Which is?
Yung yung sinabi ko noon, ganun pa. Antayin na lang natin matapos yung information.
Nauna nang itinanggi ni Go na may kinalaman siya sa mga pagpatay sa war on drugs. Wala rin daw basehan at unfair ang pagkakadawit sa kanya. Samantala, yung iba pang 4 na co-perpetrators na pinangalanan na sina Senator Bato de la Rosa, dating Davao Police Chief Vicente Danao, dating NBI Regional Director Dan Tigueran at dating Justice Secretary Vitaliano Aguirre ay wala pang sagot ng hingan natin ng pahayag. Bok?
Okay, Camille, balikan lamang natin. Ano ba ang sinabi ng prosecution kahapon tungkol dun sa mga co-perpetrators?
Bok, ayon sa prosecution, tinulungan ng mga co-perpetrators si Duterte sa operasyon na binuo nito ng grupong Davao Death Squad. Ipinakita rin ng prosecution yung chain of command ng grupo at papel ng mga kasabwat para gawin ang mga pagpatay. Narito ang paliwanag ng prosecution.
And they had a hierarchical pyramid-like structure. At the very top, as mayor, Rodrigo Duterte. Under him were co-perpetrators, some of whom I have mentioned. The co-perpetrators had different roles, but one of them was to relay orders and instructions down from Mr. Duterte to the DDS handlers, and also to relay reports back up to Mr. Duterte.
Bok, sa mga oras na ito ay nagpapatuloy na yung pagdinig sa ICC at tinatalakay na nga itong mga partikular na naging papel na mga kasabwat para magawa ang krimen. At partikular na na-mention dyan, Bok, ng prosecution, itong first na memorandum circular na inilabas nung kahahalal lamang nito ni Senator De La Rosa bilang PNP chief na pinangalanan nga na Project Oplan Barrel. At kaugnay niyan, may lumabas din na pinakabagong survey ang SWS na kung saan nagsasabi na 53% ng mga Pinoy ang nagsabi na sang-ayon sila na dapat papanagutin si Senator De La Rosa sa mga pagpatay. 44% naman ang nagsabi na dapat ikulong si De La Rosa sakaling maglabas ng bagong warrant of arrest ang ICC. Wala pang tugon dyan si De La Rosa na hanggang ngayon ay hindi pa rin nagpapakita sa Senado simula pa noong Nobyembre noong isang taon. Yan muna ang latest. Balik sa iyo, Bok.
Ulat ni Camille Samonte live mula sa Senado. Balikan natin ang ulat ni mobile journalist Julie Baiza tungkol sa reaksyon ng Malacanang sa mga pahayag ng abogado ni Duterte laban kay Pangulong Bongbong Marcos. So, Julie, ano ang sinabi ni Attorney Nicholas Kaufman at ano naman tugon ng Malacanang?
Bok, balikan nga natin yung sinabi ni Attorney Nicholas Kaufman sa ICC kahapon. Sa kanyang opening statement sa pre-trial chamber, pinagkumpara niya yung estilo ng pamumuno ni Pangulong Bongbong Marcos at ni dating Pangulong Rodrigo Duterte. Si dating Pangulong Rodrigo Duterte raw, sinsero at may isang salita, habang si Pangulong Bongbong Marcos tila or pawang nagsasalita raw sa hangin. Ang inihalimbawa ni Kaufman ay yung sinabi daw ni PBBM noon na hindi makikipagtulungan ang pamahalaan sa ICC sa anumang paraan. Pero nung naaresto daw si dating Pangulong Duterte, ilang ulit daw itinanggi ng administrasyon na may alam or nakikipagtulungan at wala silang kinalaman sa pag-aresto sa dating Pangulo. Taliwas daw yan, Bok, doon sa nakuha nilang phone transcript. Narito ang pahayag ni Attorney Nicholas Kaufman.
One of these parties was boasting about how he was acting as the silent partner of President BBM, managing a scheme to funnel witnesses to this court while all the time ensuring that he could guarantee President BBM's plausible deniability. So it is indeed the defense case that President Ferdinand Marcos Jr. set out to neutralize Rodrigo Duterte and his legacy.
Bok, hindi naman pinalampas ni Palace Press Officer Undersecretary Claire Castro yung pahayag niya ni Kaufman sa panayam ng One Balita Pilipinas ng 1PH. Sinabi ni Castro na hindi totoo na planong inutralize ni PBBM ang legacy ni Duterte. Gawain daw yan ni Duterte. Pakinggan natin ang pahayag ni Palace Press Officer Claire Castro.
Ang dami niyang ni-neutralize patungkol sa media na mga di umanong karibal niya sa politika. At isa ng ebidensya dito ng pag-neutralize. Inamin mismo ni Mayor Magalong na siya ay oversight committee head ng Tokhang. Umamin siya na base sa kanyang report, kung meron man, ay maraming pinatay sa panahon ng EJK nang walang basihan.
Bok, nagkomento rin si Yusek Castro doon sa sinasabing nakuhang transcript o phone transcript ng pag-uusap umano ni PBBM at ng isang silent or tinawag niyang silent partner. Narito yung pahayag ni Yusek Castro.
Unang-una, pinabubulaanan yan. Pangalawa, ano to, anti-wiretapping? Gumagawa na naman ba sila ng illegal? Sanay na sanay silang gumawa ng krimen. Walang katotohanan niya sinasabi ninyang yan. Ito'y gawa-gawa lamang at para mailihis yung issue ng pagpapapatay, yung karumal-dumal at madugong extrajudicial killings na ginawa.
Okay, Julie, anong reaksyon ng Palasyo sa sinasabi ni Kaufman na walang isang salita si Pangulong Marcos tungkol sa pakikipagtulungan ng gobyerno sa ICC?
Bok, sa programang Good Morning Kapatid, sinabi ni Yusek Castro na inililihis lang daw ni Kaufman yung usapin. Ang usapin daw dito, yung crimes against humanity ni dating Pangulong Rodrigo Duterte at hindi si Pangulong Bongbong Marcos. Narito muli ang pahayag ni Yusek Castro.
In the first place, parang wala siyang dininay doon sa mga akusasyon kay dating Pangulong Duterte. Pinapahid na lang niya doon sa ginawa di umano ng administrasyon para ma-surrender ang dating Pangulong Duterte doon sa ICC. Hindi yun ang usapan eh. Ang usapan, yung patayan. Yung mga magkakasabwat kayo di umano para dito gawin isang common plan na pumatay.
Okay, Julie, maiba naman tayo. Anong sabi ng palasyo sa pahayag ni Atty. Harry Roque na gusto raw makipag-ayos ng Pangulo kay VP Sara Duterte pero ang tumanggi raw ay yung bise?
Bok, sabi ni Yusek Claire, sinungaling at saka parlor talk lang daw yung sinasabi ni Harry Roque, ni Attorney Harry Roque, no? Problema rin daw kasi kay VP Sara, palagi siyang naniniwala sa mga, sabi ni Yusek Claire, kwentong barbero ni Harry Roque na ang sabi pa niya, source naman daw ng fake news. Yung pagtanggi naman daw ng bise na pakikipag-ayos sa Pangulo, pagpapakita lang daw nung kanyang tunay na kulay. Bok.
Okay, Julie, in the past 4 days, 2 beses nakapagkita sina Pangulong Marcos at si Naga City Mayor Leni Robredo. Una sa Naga City at sunod naman kahapon dun sa Malacanang. May kinalaman ba ito sa 2028 elections?
Bok, muling iginiit nga ni Yusek Castro na wala daw talagang bahid ng politika yung naging pagkikita. Ang ilang ulit daw na pagtatagpo, patunay lang na pareho na silang mahusay magtrabaho. Pinapakita rin daw ni Pangulong Bongbong Marcos ngayon na walang kulay yung politika, walang kulay ng politika yung kanyang pamumuno. Yan muna ang latest. Balik sa'yo, Bok.
Ulat ni Mobile Journal, Julie Baiza, live po mula sa Malacanang. Sa puntong ito mga kapatid, alamin natin ang update sa confirmation of charges hearing ni dating Pangulong Duterte sa ICC. At live po mula sa The Hague, Netherlands. Nauna sa balita si News 5 anchor Angela Lagunzad Castro. Angela, ano na ang tinatalakay ngayon sa day 2 ng pagdinig?
Hi, Bok. Tama ka, nandito pa rin ako sa ICC para nga sa confirmation of charges ni Pangulong Rodrigo Duterte. At of course, ngayon 32 minutes pa lang ang natatapos. 32 minutes pa lang ang natatapos ang nagagamit para dito sa sa nangyayaring confirmation of charges at doon tinalakay ang mga bagong ebidensya na pinresent ng prosecution. Doon pinakita yung sinasabing the so-called PRRD list or narco list kung saan mayroong pinakitang spreadsheet doon na may mga personalities at binanggit din doon sa kanilang mga presentasyon na lahat daw ng mga binanggit doon sa mga narco list ni Pangulong Rodrigo Duterte ay namamatay. Kasama na sa mga binigay na example ay yung sila Reynaldo Parahinog at saka sila Espinosa. Tapos ay pinakita rin doon sa mga may mga video clips mula sa mga news organization ay pinakita ang prosecution tungkol doon sa mga pagmumura ni Pangulong Rodrigo Duterte at pagpapakita niya mismo nitong narco list itong Excel spreadsheet at meron pang mga parang ang sinabi niya sa media na itong mga human rights na ito, may pagmura siyang sinabi doon at sinabi niya papakain ko tong papel na to sa kanila. Ilan lamang yun, Bok, dun sa mga ipinresenta ngayon. Lumabas muna ako para makapagkwento sa'yo. So, yun muna, Bok.
Okay, Angela, kahapon nagkaroon ng pagkakataon ng depensa na magsalita at ginit nila na inosente si dating Pangulong Duterte. Ano namang reaksyon ng kampo ng mga biktima?
Sa programang Sa Totoo Lang ng 1PH, sinabi ni Attorney Nery Colmenares na abogado ng drug war victims na nagulat sila dahil basic daw ang inilatag na depensa ng Duterte camp. Niwala nga raw ebidensya para i-counter ang mga alegasyon ng prosekusyon at hindi raw maituturing na depensa ang sinasabi ni Attorney Nicolas Kaufman na hyperbole or exaggeration lamang ang mga sinabi noon ni Duterte tungkol sa mga pagpatay. Pakinggan po natin ang pahayag ni Attorney Colmenares.
Nagulat kami kasi napaka-basic ng depensa na yan. Yung hyperbole kasi o joke, Pag walang namatay, pwede nga sabihin, joke nga lang yan, tawa ng tayo. Pero ang problema ni President Duterte, matapos siya mag-hyperbole at matapos siya mag-joke, libo-libong namatay. Hindi ko alam kung makumbinsin nila ang korte, pero I think maraming Pilipino hindi makumbinsin na wala siyang intensyong pumatay.
Well, Angela, kahapon sinasabi ng kampo ng mga biktima na merong virus of impunity na kumakalat sa bansa dahil kay dating Pangulong Duterte. Anong reaksyon dito ng kampo ng dating Pangulo?
Well, Bok, sa panayam sa programang The Big Story ng One News, may reaksyon dyan si Attorney Salvador Panelo na dating Chief Presidential Legal Counsel ni Duterte. At ayon nga sa kanya, repetitive propaganda ang mga sinabi ng prosekusyon at kampo ng mga biktima laban kay Duterte. Speculation at hearsay at hindi suportado ng ebidensya. Nasagot din daw ni Attorney Kaufman ang mga ibinato ng prosekusyon at bumwelta rin itong si Panelo sa sinabi ni Attorney Joel Butuya na kumakalat umano ang virus of impunity sa bansa. Pakinggan po natin ang naging pahayag ni Attorney Panelo.
Yung sinasabi niyang virus of impunity, I think he's referring to the virus of lies that they and he, people like him, have propagated all these years against the former president. Silang kailangan bakunahan ng katotohanan.
Angela, nakausap mo ba ang defense team matapos ang unang araw ng pagdinig? Kamusta raw ang dating Pangulo?
Well, kanina nakausap nga natin bago tayo pumasok dito sa media center si Attorney Nicolas Kaufman at natanong natin kung nakausap nga ba niya si Pangulong Rodrigo Duterte at sabi nga niya masaya raw si Pangulong Duterte sa naging takbo ng pagdinig kahapon. Pakinggan po natin ang pahayag niya.
I can assure you that he's extremely happy with the way things are going at the present moment in time. He is always good spirits. He's an 8-year-old man. He has all the conditions which one would expect of an 8-year-old man, with the extra conditions which accompany his cognitive state.
So, hindi magsasalita today ang defense pero examine daw nila ang ebidensya. Siyempre kasi ang pagkakataon nila para makapagsalita ay sa Thursday pa. No? So, hindi raw irrelevant sa kaso. Actually, natanong ko rin ito, nakausap ko si Attorney Kaufman kanina na sinabi ko ano yung masasabi niya doon sa sinabi ng iba katulad na lamang ni Attorney Nery Colmenares sa hanay ng mga biktima na sinasabi nila wala namang basihan at irrelevant yung pagbanggit niya o pag-involve niya kay Pangulong Bongbong Marcos sa kanyang opening statement yesterday. At of course, sabi niya ay irrelevant, relevant naman daw itong pagbanggit niya kay Bongbong Marcos dahil nga sa kanilang ebidensya na pinupunto ay si President Bongbong Marcos nga daw ang gagastos at nagpaplano nitong mga kaso dito sa ICC. Of course, appeal to emotion statement niya yesterday dahil pinasikat daw na Pangulo ito ng Pilipinas. So hinihintay pa raw nila ang desisyon sa challenge nila kaugnay ng jurisdiction ng ICC. So yan muna ang latest dito. Balik sa iyo, Bok.
Ulat ni Angela Lagunzad Castro, live po mula sa The Hague, the Netherlands.
Ilang oras na lang at magsisimula na nga po ang ikalawang araw ng confirmation hearing ni dating Pangulong Duterte sa ICC. Makibalita tayo sa sitwasyon doon mula sa The Hague, the Netherlands. Nasa linya ng telepono si Angela Lagunzad Castro. Angela, anong oras na ba dyan ngayon at ano ang inaasahan natin ngayong ikalawang araw ng hearing?
Hi Ruth, it's actually 7:39 in the morning here in The Hague, Netherlands. At tulad nga ng nasabi mo, natuloy na kahapon ang confirmation of charges hearing ni dating Pangulong Rodrigo Duterte sa ICC matapos nga 5 buwang pagkakadelay. So ngayon Ruth sa pangalawang araw ng confirmation of charges ni dating Pangulong Rodrigo Duterte, ay aasahan po natin ang pagpapatuloy ng submission on the merits ng prosekusyon at ng panig ng mga biktima sa pamamagitan ng kanilang legal counsel. Ang ibig sabihin nito ay maglalabas pa ng iba't ibang ebidensya ang dalawang kampo upang pagtibayin ang kaso laban kay Duterte. Kumbaga, hindi na lang usapin ngayon yung kung ano ang sinabi, kung ano-ano ang nangyari at kung di kundi kung ano ang nangyari at kung may sistemang nagpapatupad nito. Mula sa maanghang na mga pahayag, ngayon susuriin kung may mga konkretong mekanismo nga ba sa likod ng mga operasyon, no? Kaya ang tanong ngayon, may ebidensya ba na ang mga salita ay naging aktual na polisiya? Ano ang mga naging resulta ng mga naging pahayag ng dating Pangulo? Yan yung isa sa mga ilan pa sa mga alamin natin mula kahapon. Yan ang karagdagang ilalabas pa ngayon at aabangan uli natin mula sa prosekusyon at mula sa mga biktima. Ganun pa rin ang oras, Ruth, 10 a.m. to 3 p.m. The Hague time ang simula ng confirmation of charges dito. At dyan sa Pilipinas naman magsisimula 5:30 ng hapon. Merong 30-minute delay dahil na rin sa usapin ng seguridad. So bukas naman ay nakatakda ang araw ng pahinga. Pero pagbalik sa Huwebes, February 26, dito naman inaasahan ng submission on the merits ng depensa. Ibig sabihin nito, diretsahan ng haharapin ng depensa ang mismong akusasyon laban kay dating Pangulong Duterte at hindi na ito tungkol sa technical issue, sa proseso or yung ang tatalakayin dito ng depensa at kung talaga lang na may sapat, kung may talagang kung talaga bang may sapat at matibay na ebidensya para sasabihin may krimen at pananagutan si dating Pangulo. Kumbaga, Ruth, dito susubukan ng depensang ipakita na mahina ang argumento, ang pundasyon ng mga paratang ng prosekusyon. So yan muna ang latest mula dito sa The Hague, Netherlands. Balik sa'yo dyan.
Angela, ito pa ulit-ulit namang sinasabi, even sa statements ng ICC na hindi pa ito, yung actual na trial, hindi pa ito yung magde-decide sila kung guilty o hindi ang dating Pangulo. Pero noong una kasi lumutang na posibleng may mga testigo. O mailalabas ba yan ngayon sa puntong ito na submission pa lang ng merits? Or ano ang, halimbawa, mga documents lang ba ito, mga litrato? Ano kaya yung posibleng ebidensya na makita natin?
Ako, Ruth, yan ang paulit-ulit natin kinumpirma kay Attorney Cristina Conti na talagang at this stage of the case, dahil pre-trial pa lang ito, hindi ito yung actual, wala tayong makikitang mga mismong witnesses dito, So mostly audio, video presentation, documents ang makikita natin kung, at actually sabi nga base doon sa House Rules kahapon na sinabi ng pre-trial chamber ng mga judges doon, ang bawal silang magbigay ng eksaktong pangalan, identity ng mga witnesses, Yun ang sabi nila doon, unless kung kinakailangan ito ay pag-uusapan muna in a private session, tsaka nila aaprubahan kung talagang kailangan ibigay yung pangalan sa publiko. But for now, at this stage, wala tayong makikitang mga witnesses, wala tayong makikitang mga pangalan ng mga witnesses, at talagang audio, video presentation at mga dokumento, mga pictures yan ang mga makikita natin sa ngayon. So kung meron man tayong makikitang panibago dito sa aking sinabi, maaari yung pagdidesisyonan ng pre-trial chamber.
Yan pong express report ni Angela Lagunsad Castro mula sa The Hague, the Netherlands.
Sinubukan umano ni Pangulong Bongbong Marcos na i-neutralize si dating Pangulong Rodrigo Duterte. Yan ang akusasyon ng kampo ni Duterte sa pagdinig ng International Criminal Court kaugnay sa reklamong kinahaharap ng dating Pangulo. At kaugnay nga nitong balitang to, makakausap natin live via Zoom si Palace Press Officer Claire Castro. Magandang umaga po yung si Claire.
Yes, good morning Nikki at good morning sa lahat ng sumusubaybay sa inyong programa. Good morning po.
Ayun, good morning Yusek. So malamang sa malamang narinig nyo na po to. Sumusubaybay po kayo sa ICC hearing. Ano po bang reaksyon nyo dito nga sa pahayag ni Kaufman na meron daw pong transcript ng isang interview? It was a transcript na there's like collusion daw na isinishield si President BBM about what's happening with the ICC hearing?
Unang-una, sabi nga natin, nag-react na tayo dyan. Sinabi natin parang ang nagsasuffer ng severe cognitive impairment ay walang iba kung hindi itong si Attorney Kaufman at hindi ang kanyang kliyente. Dahil matatandaan natin, ang kasong to ay crimes against humanity na sinampa pa as early as 2017. So bakit lagi niyang pinapahid kay Pangulo Marcos Jr. itong mga kaso, itong mga di umanong kasalanan ng pagpatay, ni dating Pangulong Duterte. Hindi na lang niya tutukan kung paano niya didepensahan at i-deny yung mga bintang ng pagpapatay at architect pa di umano itong si dating Pangulong Duterte, mastermind ng itong common plan among the DDS. So, hindi niya tinutukan yan. Instead, pumunta siya sa politika paawa, appealing to the emotions of the Filipino people. So, hindi konektado yung si Pangulong Marcos Jr. doon sa mga patayang naganap noong 2011 hanggang 2019.
Pero Attorney Claire, yun nga po yung kinuha niyang, kumbaga pinili niyang anggulo, yung political persecution. And as a trial lawyer, paano po kung may pruweba nga pong authentic ito? Again, ito pong interview na ito ay galing sa sa prosecution side. Bakit nga po ba napili itong dokumento ng prosecution to have?
Unang-una, sabi nga natin, paano niyang i-connect si PBBM doon sa mga crimes na di umanong nangyari noong 2011 to 2019. Diba? So, paano niya i-connect? Nangyari na to eh. Yung kay Pangulo, sabihin natin, ibinibintang nila, ginagawa nila na naratibo, pero that's after math na eh. Tapos na yun eh. Ang ginawa lang ng Pangulo dito at ng administrasyon ay ipatupad yung RA 9851 natin kung saan tayo ay may obligasyon din kapag ka nasa international tribunal na or state ay nag-i-start na magkaroon ng pag-iimbestiga doon, we can dispense with our own investigation here in the Philippines. So that's part of our law. And at the same time, we also have this obligation to coordinate and cooperate with the Interpol. And we also have these residual obligations na dapat nating ipatupad base sa international law din. So, hindi siya konektado doon sa binibintang ng 2011 to 2019. So, paano niya masasabi na walang kasalanan ng Pangulo sa patayan? In the first place, Nikki, parang wala siyang dininay doon sa mga akusasyon kay dating Pangulong Duterte. Pinapahid na lang niya doon sa ginawa di umano ng administrasyon para ma-surrender ang dating Pangulong Duterte doon sa ICC. And that's it. Pero ang pinupukol ng prosecution yung patayan. Sabi nga, 20 years naging mayor. Nasa power ang dating Pangulong Duterte. Pero ang coverage lang ng hearing dyan mga nangyari noong 2011 hanggang 2019. So, ang hirap kasi i-connect na dinala ako dun eh. Kasalanan ni Pangulong Marcos Jr., dinala ako dun. Hindi yun ang usapan eh. Ang usapan, yung patayan. Yung mga magkakasabwat kayo, di umano, para dito gawin isang common plan na pumatay.
So, Attorney Claire, parang we circle back, bumabalik po tayo dun sa kung ano man po yung nilalaman nung clip na yon or yung audio clip na yon, dahil po sa coordination natin sa Interpol. Kasi yun nga po yung paulit-ulit sinasabi ni Attorney Kaufman, no, na si Ombudsman Jesus Crispino Remulla did say na hindi daw po tayo coordinate with ICC, and yet this happened.
Yes, that's true. Kasi wala ng jurisdiction ngayon ang ICC. But even our own Supreme Court says na meron jurisdiction ng ICC sa lahat ng mga nangyari of all the crimes committed prior to the withdrawal from the Roman Statute or ICC. So may jurisdiction ng ICC doon sa mga cases na naganap noon. So kaya nga parang hindi mo dapat gawing depensa yung pag-surrender sa iyo doon. Ang dapat mong tutukan, Attorney Kaufman, yung naganap noong 2011 saka 2019. May mga witnesses may mga biktima di umano. So ba't hindi ka magtutok doon sa mga statement, sa mga testimony ng mga witnesses? Huwag mong dalhin dito sa pamumulitika. Di ba?
Attorney Claire, so second day na po tayo, no? Kumbaga, kahapon po yung lapagan ng accusations, ngayon po more on the merits na or the facts of the cases. So, kayo po as a trial lawyer, what's your assessment po sa kasalukuyang paggulong ng ICC hearing? Kasi hindi pa po ito yung trial, di ba? Kumbaga, we can also say na ito yung pinaka-importanting parte kasi kung hindi po, kumbaga, hearing pa lang po kung magkakaroon ng trial. Maaring hindi na magkaroon ng trial altogether.
Yes. Sa akin pananaw, no, my take, hindi take ito ng palasyo, hindi i-take ito ng Pangulo. Sa nakikita ko kasi, masyadong maraming na ibigay na mga facts itong prosecution. Kung ikukumpara mo sa paninisi. So sa ngayon kasi ang rebuttal lang naman ni Attorney Kaufman pamumulitika. Sinisisi pa yung media, 'di ba? Maganda daw yung mga larawan, kumbaga yung mga family grieving, yun yung mga ini-inflate, 'di ba? Para out of context yung lahat ng pangyayari. Lahat sinisisi niya sa iba, tinuturo niya sa iba, na hindi niya mismo tinututukan yung mga depensa or rather yung mga facts na naibibigay ng prosecution. So kung ako yung judge, para siyang depensa lang na wala. Hindi mo makita kung paano niya i-deny yung akusasyon na may common plan among the co-perpetrators to commit the crimes against humanity. Wala akong nakikita so far. Baka sa susunod na araw may makita na tayo kay Atty. Kaufman. Pero sa ngayon, wala tayong nakikita.
Oo nga po. Kasi I think sa 4th day pa po yung more on the defense side. Puro prosecution po yung mauna. So, total, lagi naman pong nadadawit yung pangalan ng Pangulo. Nagmo-monitor po ba si PBBM sa confirmation of charges hearing nga ng ICC?
Hindi siya nagmo-monitor, pero syempre kailangan siya i-update. Kasi maraming trabaho ang Pangulo, Nikki, no? Oops, teka lang, wala. Bakit? Wait.
Okay lang po. Okay lang po.
Hindi tumawag. Oo. So, marami may nagmo-monitor, merong kailangan siyang ma-update siya, pero it doesn't mean na kailangan niya mag-monitor dahil ang daming trabaho ng Pangulo. Ngayon, sa totoo lang, maghapon ang ang events ng Pangulo, umpisa pa lang umaga.
Okay, sige. Dako naman po tayo sa impeachment complaints, no? Laban naman kay VP Sara. Ano pong masasabi nyo, no, sa pag-usad nung proseso sa Kamara? Kasi na-refer na po itong mga reklamo sa House Justice on Committee.
Yun talaga ang proseso. Kung ikukumpara natin sa naging komento ng Pangulo nung siya ay nasasalang sa impeachment na yung mga impeachment complaints ay nakasalang, ang sabi ng Pangulo, irespeto natin yung ang proseso. Kasi proseso to eh. So, sundin lang naman nila yung batas at sila ay magdesisyon base kung ano yung makikita at maipepresenta dyan. So, sana ganun din ang Vice Presidente. Dapat wag niyang wag siya maging rude, 'di ba? Sa mga miyembro ng House of Representatives kasi trabaho lang ito eh. So kung ano yung proseso, dapat yun lang yung gawin. Kung ano yung nakikitang ebidensya, doon na lang siguro sila tumingin. Kung may ebidensya laban kay Pangulo, ay rather laban kay Vice Presidente, then so be it. Kung wala, di bahala po sila kung anong magiging decision nila yan. Basta dapat sana proseso at ebidensya. Yun lang naman po ang kailangan.
At habang dumadagdag nga po, no, itong mga impeachment complaints against VP Sara, nung mismong nagsabi po siya na tatakbo siya bilang Pangulo, may naghain po ng impeachment complaint right after. So, galing po doon, coming from that, si VP Sara, nagsabi na rin siya na nagre-recruit na daw siya ng running mate noon pa, nung nakaraang taon pa po. May mensahe po ba kayo? What's your take on that?
Decision niya yun eh. Talaga naman kailangan humanap siguro siya ng partner. Partner na talaga magtatrabaho sana. Magtatrabaho na dapat. Isang Vice Presidente na nagtatrabaho. Kasi iba yung sitwasyon natin ngayon eh. Tama, sa sunod ng Vice Presidente, magtrabaho na.
Kayo po ba ay may mensahe din sa kanyang magiging katandem? O meron po ba kayong idea kung sino mga posible?
Wala. Choice nila yan. Decision nila yan. It's up to them. So wala tayong magiging comment about that. Wala rin tayong magiging suggestion. Alam naman natin hindi susundin.
At sige po. Sila na po bahala doon, no? Yusek, kamustahin po natin yung yung isa pa po itong medyo maingay sa social media kasi makakasunod pong nagkikita si Pangulo at ang dating VP, si Naga City Mayor Leni Robredo.
Mayor Leni.
Meron nga po ba silang pag-uusap?
Sa totoo, wala talaga. Siguro nakita lang nila na dalawa pala silang leaders na nagtatrabaho. Siguro at the time na nangangampanya sila, hindi niya nakikita ni Mayor Leni kung gaano kasipag itong si Pangulo Marcos Jr. Pero ngayon naging Pangulo si PBBM, nakita niya na walang kulay. Kung sino may kailangan, lokal na pamahalaan, leader, kailangan ng tulong ng national at nakita, ito ang dapat natutukan, walang kulay, walang sinisino. Diba? Yun yung dapat eh. Tignan nyo, dati magkatunggali sila. But, Mayor Leni, nakita niya kung paano magtrabaho si PBBM. And at the same time, bago pa ito, Nikki, nabanggit na rin ni Mayor Leni na sang-ayon siya sa tinutungo ng pagtrato ni Pangulong Marcos Jr. ng administrasyon na ito patungkol sa ating karapatan sa West Philippine Sea. Sabi nga niya, nasayang yung 6 na to. Rather, sabi niya pa, 8 years na hindi ganito ang naging pagtrato sa ating karapatan sa West Philippine Sea. At sinasabi niya, sang-ayon siya sa tayo ng Pangulo patungkol sa ating karapatan. So makikita mo na hindi na kailangan na manira kung talaga may ginagawa ang Pangulo at ang administrasyon na hindi nakikita mismo ng Vice Presidente dahil lagi siyang sinasabing walang nagagawa ang Pangulo. Zero foreign policy. Walang independent foreign policy. Samantalang yung dating katunggali ni Pangulong Marcos Jr. na si Mayor Lenny, nakikita niya kung saan tayo ng Pangulo at ito ay pinupuri pa niya. Diba?
Okay, siguro last question na po, no? Bukas po kasi 40th anniversary na ng EDSA People Power Revolution. Sinusulong nga sa Kamara na gawin daw tong non-working holiday. Ano pong masasabi ng palasyo dito considering the past couple of years ay special working day po ito?
Kung gagawin po nila yan at okay naman po at walang masasagang anumang masasagasaan na anumang karapatan, yan naman po ay maaaring tignan ng Pangulo at aaralin at kung mapapasa kamay ng Pangulo to kung meron mang bill, tignan po natin ang kanyang magiging desisyon. Hindi naman po ito masama.
Ayun. Maraming salamat po sa pagising ng maaga and for speaking to us, Palace Press Officer Claire Castro.
We speak today on behalf of the thousands of victims and surviving families who suffer immeasurable harm under the so-called anti-drug campaign conducted during the administration of the suspect, former President Rodrigo Duterte. We speak for families who cannot be here, mothers who buried their sons, children who lost their parents, the spouses who now raise families alone, and communities that have lived for years under fear and silence and that continue to bear the consequences of violence that swept through their neighborhoods like a storm. These victims appear today before you not as mere statistics or distant figures or images in report as pictured yesterday by the defense, but as human beings whose rights under the Rome Statute have been violated in the most profound ways. These proceedings relate to what has been labeled the Duterte's war on drugs and Duterte's bloody war on drugs. However, the campaign, as I will refer to it during my presentation, was less about combating the drug trade itself and more about policing poverty and social inequality. As the evidence on the record unequivocally shows, individuals targeted by Mr. Duterte anti-drug operations overwhelmingly came from impoverished communities where social mobility is limited and opportunities are scarce. Drug use, particularly methamphetamine, locally known as shabu, is often more prevalent in such low-income settings where people may turn to substances as a coping mechanism for their harsh living conditions. In these communities, structural conditions, including the absence of adequate mental health services, limited access to quality education, scarce employment opportunities, and the chronic stress associated with poverty, create an environment in which substance use is more likely to emerge. Therefore, patterns of drug use do not arise in a vacuum. They reflect deeper systemic inequalities and long-standing patterns of socio-economic marginalization. The campaign disproportionately affected the poor and marginalized, especially in urban informal settlements marked by high levels of poverty. While the rhetoric of war focused on eradicating drug dealers and users, it was the most vulnerable members of society, those with the least power and resources, were caught in the crossfire. A significant number of the ones killed had little or no criminal history and were often accused of minor drug-related conduct or perceived drug use by the authorities. These were people living in poverty, were treated as expendable by a system that failed to prioritize their protection and to address the structural conditions underlying their struggles. Rather than addressing the root causes of drug addiction, such as poverty, lack of education, unemployment, and inequality, the Duterte administration framed the issue as a criminal one, focusing on punitive enforcement over social responses. Mr. Duterte's response was a selective, violent crackdown of the most vulnerable, recasting conditions of marginalizations as grounds for criminal targeting, rather as manifestations of social injustice. Framed on its face as a campaign against illegal drugs, it in reality reflected broader social political dynamics, including the targeting of marginalized communities, the use of state violence, and the deflection of attention from deeper structural problems. Mr. Duterte is charged under Article 7(1)(a) of the Rome Statute with the crimes against humanity of murder and attempted murder allegedly committed between 1st November 2011 and 16 March 2019 in or around Davao City during the period in which he was mayor of the town, and across the Republic of the Philippines during his term as president of the country. The prosecution presented ample evidence showing that each of the contextual elements of crimes against humanity is satisfied at the required threshold for confirming the charges. During the period covered by the charges, the Davao Death Squad and the national network created by Mr. Duterte to commit the crimes carried out an attack against the civilian population within the meaning of Article 7(2)(a) of the statute, as reflected in a course of conduct involving the commission of multiple murders and attempted murders. The victims' accounts of events corroborate the prosecution evidence and show that the crimes they suffered were not spontaneous or isolated acts of violence, but rather a planned, directed, and organized attack against them. The attack was massive, carried out collectively with considerable seriousness, and directed against a multiplicity of civilians. The victims were all civilians. The repeated lethal operations were conducted in residential and other civilian settings. As already indicated, the victims largely came from marginalized communities, were suspected by the authorities of involvement in criminal, often drug-related activities, and together with their families, they were targeted in their homes and neighborhoods. The attack was widespread and systematic, and we refer, Your Honor, to Annex D and E of the prosecution pre-trial brief. The attack was widespread because of its large-scale nature and the number of victims. In this regard, the number of victims affected by the events within the charges is one of the most relevant factors to be taken into consideration for the purpose of determining under the chapeau of Article 7(1) of the statute whether the attack was widespread or systematic. The broad geographical spread of the victimization, combined with a significant number of victims, confirm the wide scope of the attack. As the prosecution has made clear yesterday and today, the instances of murders and attempted murders in the document containing the charges and in the pre-trial brief are simply illustrative of a much broader pattern of victimization. In fact, the actual scale of victimization extends well beyond the 49 incidents affecting 78 victims presented by the prosecution. The prosecution itself referred to thousands of civilians murdered. And we recall here the content of paragraph 73 of the prosecution pre-trial brief, as well as the remarks by Ms. Croft just 15-20 minutes ago. As reported by Human Rights Watch in a report published in 2022, since 2016, the Philippine police have admitted its involvement in the death of more than 6,200 people in drug raids across the country. In a 2020 report, the United Nations Office of the High Commissioner for Human Rights reported 8,663 deaths occurred in the drug war. The Human Rights Commission of the Philippines and domestic human rights group report death tolls that are 2 to 3 times higher than the UN figure. The attack was also systematic, well-planned, and well-executed, following a standard modus operandi. In many cases, it began with an individual receiving a visit or a phone call from an official from the local barangay, informing them that they were on a drug watch list drawn up by barangay officials and the police. In practice, these visits function less as warnings than as a means of confirming the identity and whereabouts of the intended target. As one victim reported, I quote, "A barangay official told my husband to surrender to the police because he was on the watch list as a drug user. He had given up drug use months earlier, so did not go. 2 weeks later, 3 armed masked men wearing bulletproof vests arrived at our home in Manila and handcuffed him. I could hear my husband begging for his life from outside the room. We were crying, and the other armed men threatened to kill us as well. Moments later, my husband was shot dead." End of quote. Survivors, relatives, and neighbors consistently recount that armed men typically work in groups of 2, 4, or a dozen. They wore either police uniform or civilian clothes, often all black, with their face concealed by balaclava-style headgear, masks, baseball caps, or helmets. They carried handguns. As one victim explained, and I quote, "On 6 June 2017, at about 9:45 in the evening, I was at home with my husband, and our children were sleeping upstairs. 4 unidentified men wearing helmets and bonnets arrived at home looking for my husband. They broke down the front door. I started begging them to spare the life of my husband. The men pushed me away. My husband was shot in the chest and fell face down. While lying face down, he was shot 5 more times in the nape and head. The children woke up terrified because of the gunshots." End of quote. Attackers frequently travel by motorcycle, typically with 2 individuals on a single bike. Often a van, invariably white or black, and at times bearing markings associated with police vehicles was also present. They banged on doors and barged into rooms. The attackers did not identify themselves or provide warrants. Family members report hearing beatings and their loved ones begging for their lives. And I quote again from the recollection of one of the victims. 5 masked armed men broke into our house in Bulacan province where my father was playing cards. We could see him kneeling in a surrendering position. The men grabbed him and slammed him into a concrete wall several times. And then, just they throw him outside. We saw the shooting. We were just there. My father's face was bleeding from being hit, and he was begging them for mercy when he was shot. End of quote. Another victim explained, quote, "My father collapsed to the floor but still tried to move, begging for his life. Yet the man continued shooting him. I couldn't count how many times I was so afraid. We also heard successive gunshots from outside. Later we found that also 2 of our neighbors were killed." End of quote. The shooting could happen immediately, behind closed doors or in the street, or the victims would be taken away by the gunman only for shots to be heard minutes later and the body to be discovered by local residents. At times, bodies were dumped elsewhere, sometimes with hands tied or heads wrapped in plastic. Relatives typically found them after being alerted by policemen or by the neighbors. A victim recalled, quote, "6 masked armed men broke into the house where a small group, including several teenagers, were watching television. The men arrested and beat 2 young boys they believed were drug suspects and then took them away on motorcycles. A half hour later, after hearing from a uniformed policeman, we, referring to the relatives, rushed to a nearby bridge to find their bodies, both with gunshot wounds to the head, their hands tied with cloth. The gunmen were still at the scene, while uniformed police cordoned off the area." Another victim recounted, quote, "A week after his brother was killed, 10 police officers, some in civilian clothes, arrested my other son and took him to the local barangay office. That evening, masked armed men abducted him from the barangay office. Shortly afterwards, his body was found under a bridge a block away. When we found him, we saw that his entire head had been wrapped in packing tape and his hands had been tied behind his back. He had been shot execution style through the mouth." End of quote. And another one, quote, "The body seemed like it was just thrown out. The nails were removed, one eyeball was missing, stuffed by cotton." End of quote. Relatives and witnesses often saw uniformed police in the immediate surroundings of the incident securing the perimeter. Special crime scene investigators typically arrived within minutes. In numerous cases, an unregistered 38 or 45 caliber gun and a packet of shabu were found placed beside the body. And instead of fleeing from the police, the gunman would mingle with them. As one of the victims described, I quote, "On 7 June 2018 in the morning, I was at home where I saw my son coming back from his work on the opposite side of the street. Suddenly, I saw 8 policemen, 3 in uniform and 3 in civilian clothes. 2 of them crossed the street. They took my son and banged his head against the wall. They accused him of selling shabu. He denied. He was then taken to the door of a house. He was shouting, "Mama, help me!" I took a piece of wood and hit one policeman. Suddenly, one policeman pointed the gun against my son. He shot twice, at the head and at the chest. While in shock, I saw one police officer placing 4 packets of shabu and a gun around the body of my son. End of quote. The same account of another victim who simply recalled, after the shooting of my son, who was only 19, uniformed police showed me his body in the house and a .45 caliber handgun next to his body. I told them that my son could not afford and did not possess a gun, and therefore could not possibly have attempted to shoot at the police. I said he cannot even pay the rent. His sister paid the rent for him. End of quote. On occasions, victims were still alive when found by the relatives and taken to the hospital, where they later succumbed to their injuries. Survivors recount the terror and enduring feeling of still being hunted as follows, and I quote, "In September 2016, a police officer pretending to be a commuter boarded my tricycle. He asked me to pass by the police station. There, I was stopped by a group of men who turned to be police officers. I was taken to the precinct, beaten, and forced to reveal the identity of drug pushers. I didn't know. Later that evening, I was taken to a dark place and shot multiple times. Despite the injuries, I managed to escape and save my life. I still have the consequence of the injuries, and I feel deep sadness, anger, and fear of being catched again." End of quote. Another survivor explained, quote, "They killed my 4 friends kneeling and defenseless. I heard a barrage of gunshots, voices, and one officer saying, 'Let it be. Let's say they fought back and let's leave the evidence.' I lay next to one of my friends pretending to be dead. When the armed officer left, I crawled out of the room and headed towards the edge of a ravine. Holding my chest with one hand to stop the bleeding, I slid downwards and fell to the creek bed. I crossed it, climbed the hill on the other side, and walked toward the highway. There, I encountered someone I knew and desperately begged for help." End of quote. Although the charges concern only the crimes of murder and attempted murder, victims' accounts also reveal widespread acts of torture, ill treatment, and rape. Young people were particularly exposed to torture and cruel and inhuman treatments, including unlawful arrest. A number of victims participating in these proceedings were minor when they were attempted to be killed, and a number of victims participating in the proceedings recount the killing of their nephew, son, cousin, who was under 18 at the age of killing. And this morning, Mr. Jeremy provided the example of Kian de los Santos, who was 17 at the time of his killing. Reported forms of torture include beating, kicking, slapping, blows to the head, electrocution, and death threats. On several occasions, law enforcement officials used arrests, inclusion in the drug watch list, and drug-related accusations as a tool of coercion to perpetrate rape and other forms of sexual violence. In September 2018, a young boy was taken by the police and brought to the precinct. His mother recounted, I quote, "At the precinct, he was repeatedly coerced into confessing a crime he was accused of. If you don't admit, your life will be the price," they threatened him. When he refused to confess, he was beaten with a gun and electrocuted. On the night of 16 September 2018, between 9 and 10, I received a phone call from my cousin urging me to go in a certain location in Manila. What I saw was a nightmare. My son had been discarded like an animal, his lifeless body lying on the boulevard, abandoned like a fish by the roadside. I rushed to the scene, but I was blocked by the police. I was not even allowed to touch or embrace my son's body. Even in death, my son was not treated with dignity. It was like they just threw my son out like a pig. I finally found him at the funeral home, where I had to pay to recover the body. I had nothing. I was bargaining as if I were buying fish. In the end, I paid approximately 45,000 pesos to take my son's body for burial. Now I wonder, will justice ever be served?
Excuse me, counsel, you have 5 minutes left.
Official police reports of these incidents invariably invoked self-defense to justify the killings, despite eyewitness accounts that portray the killings as cold-blooded murders of unarmed individuals. To bolster their claims, the police routinely planted guns, spent ammunition, and drug packets beside the bodies. While these official accounts contrasted markedly with the ones provided by the relatives, they were notably consistent among themselves, typically characterized the incidents as by-bust anti-drug operation, differing little besides the names, places, and dates. The victim was invariably described as a dealer who attempted to sell to undercover officers conducting a buy-bust operation. Specialized local anti-drug units, called Station Anti-Illegal Drug Special Operation Task Units, were usually involved. According to the reports, the victim, after being put under arrest, often uncuffed, allegedly pulled out a weapon and sought to shoot the police. In every case, the victim was killed, and none of the arresting officers were armed. In most cases, the police reporting having found shabu on or near the victim's corpse, and sometimes a gun. Often, after the killing, the bodies of the victims were brought directly to the funeral parlors. Families then had to start their calvary to find the body of their loved ones, and they had to pay high fees to retrieve the bodies. R/50082/25 had to sell the house to be able to pay for her brother's funeral and burial. Sometimes the bodies were instead left on the street or thrown into the water in a plastic bag.
My name is Robin Croft, and I will address two topics today. First, I will present on the contextual elements of crimes against humanity. And second, I will set out some of the prosecution's evidence on Mr. Duterte's individual criminal responsibility for the crimes alleged in this case. Turning first then to the contextual elements. Your Honours, the contextual elements of crimes against humanity are established in this case because, First, there was an attack against the civilian population in the Philippines. The attack targeted civilians alleged to be involved in drug-related crimes and other forms of criminality. The Rome Statute crimes alleged in this case formed part of that attack. Second, the attack was widespread and systematic. And third, the attack was carried out pursuant to or in furtherance of a state or organisational policy. This policy was to neutralise alleged criminals in the Philippines through violent crimes, including murder. The evidence establishing the contextual elements are set out in paragraphs 71 to 86 of our pre-confirmation brief. In relation to the requirement of an attack, our case is that from at least the 1st of November 2011 to the 16th of March 2019, the Davao Death Squad, or DDS, and/or the National Network carried out an attack which targeted civilians alleged to be criminals. Your Honours have heard from my colleagues how from 2011 until 2016, the attack was concentrated in Davao City. Then, in 2016, when Mr. Duterte became president, he and his co-perpetrators expanded the attack nationwide. They used the national network to do this, which, as Mr. Jeremy has explained, was comprised of state actors, such as law enforcement personnel, as well as non-police assets and hitmen. Your Honours, the locations of the murders contained in counts 1 to 3 of our document containing the charges are indicated on the map on your screens. They include 76 murders, which themselves satisfy the threshold of multiple acts making up a course of conduct. However, as Mr. Nichols has noted, the crimes in count 1 to 3 are representative and emblematic of a larger killing campaign. And the prosecution relies on a range of evidence to establish that the attack was made up of thousands of killings and other violent crimes under Article 7.1. This evidence includes datasets and the statements of documentation actors, the evidence of insider witnesses, expert analysis, and the admissions of Philippine state agencies in their public reporting. I will take your honours through some of this evidence now. During Mr. Duterte's mayoral period, hundreds of civilians alleged to be criminals were killed in Davao City. On your screens is a chart with data on extrajudicial killings in Davao based on public reporting. The data is recorded at tab 116. It shows that between 2012 and 2015, there are at least 274 extrajudicial killings in Davao City. This data is corroborated by DDS insider witnesses. Several DDS witnesses say that they each killed hundreds of alleged criminals while with the DDS. Your Honours can see on this slide quotes from one DDS witness. They estimate that, I quote, between 1,500 and 2,000 people, end quote, are buried at Laud Quarry. The quarry was only one of several places that the DDS dumped bodies in and around Davao. That's at tab 37. This witness said that they personally killed hundreds of people. They described their job as with the DDS as being, quote, just to kill small criminals, petty criminals. Out of the almost 300 people that I have killed, I never actually got to kill a drug lord, end quote. That's at tab 34. This witness's words make it clear that the target of the attack was people alleged to be criminals in Davao. Your Honours, another DDS witness who also killed hundreds of people said that the DDS targeted, I quote, suspected criminals in Davao City, including shabu users and pushers, end quote. That's at tab 58. Your Honours, as you have heard previously, Mr Duterte has himself publicly admitted that he killed around 1,700 people while he was mayor of Davao City. I quote, "They say I killed 700, they undercounted. Around 1,700, end quote." That's at tabs 10, 10.1, 10.2. This evidence, the data collected by independent organisations, the statements of insiders on the hundreds of people that they have each killed, and Mr Duterte's own admission of having killed 1,700 people while mayor of Davao, all show that the attack was widespread in the mayoral period. And the attack continued to be widespread after Mr Duterte became president, when it expanded across the country. The victimisation expanded, with the hundreds killed during the mayoral period becoming thousands in the presidential period. Your Honours can see a map of the Philippines on the slide. The colours which will emerge show the locations and density of the killings in the anti-illegal drug campaign. Purple dots indicate an area with 1 to 10 killings, while yellow indicates 500 killings. This is how the killings progressed throughout the presidential period. Your Honours, this map is based on data collected by an independent organisation which recorded at least 5,823 anti-drug killings during the presidential period. This data is recorded at tab 104. The data shows that the attack during the presidential period was widespread. As Your Honours can see from the map, it occurred across the country. It occurred over multiple years, and thousands of civilians were killed. Mr Duterte's administration effectively admitted to the large volume of the attack. They admitted that thousands of individuals were killed in anti-drug operations while Mr Duterte was president. For example, in the Duterte administration's 2017 year-end report, which you can see on your screens, the administration admitted that 3,967 drug personalities died in anti-drug operations in the first year and a half of Mr Duterte's presidency. That's at tab 106. Similarly, the Philippine Drug Enforcement Agency, or PDEA, admitted that 5,281 drug personalities died in anti-drug operations in the first 2.5 years of Mr Duterte's presidency. This is at tab 98. These admissions corroborate the widespread nature of the attack. They show that thousands of individuals were killed. Your Honours, in addition to being widespread, the attack was also systematic from its origins and throughout the charge period. The features of DDS operations demonstrate this systematicity during the mayoral period. And these features can be found in our brief at paragraphs 35 to 36 and 88 to 98. Insider witnesses described how time and time again killing operations followed the system set out on the screen. The same hierarchical structure was followed. As Mr Nichols explained, the orders flowed from Mr Duterte at the top, through a combination of other co-perpetrators, to the handler of the relevant DDS team, and finally to the physical perpetrators at the bottom. The DDS teams composed of police and non-police assets and hitmen who carried out the killings. The features of the killings were also often markedly similar. The identity or whereabouts of the victim was provided to the DDS by an informant. The perpetrators would frequently arrive to or flee the crime scene by motorcycle. They shot or stabbed their victims at close range. The victims were targeted on the basis that they were alleged to be drug users, pushers, or other criminals. And the DDS received a sum of reward money for each kill. When the attack expanded during the presidential period, it continued to be systematic because it remained highly organised, planned and coordinated. Similar systems to the one I've just described in Davao were deployed during Mr. Duterte's presidency to implement the killings. Your Honours can see some of those features listed on your screens. As in Davao, victims were targeted on the basis that they were alleged to be drug users, pushers, or other criminals. The process for killing the targets was often markedly similar. First, the victims were identified by state actors as targets and listed. As Mr. Jeremy has outlined, high-value targets were often listed on the PRRD list.
And for the record, we are in open session.
Merci beaucoup.
Thank you very much. I would like to ask parties and participants to confirm that those present in the courtroom today are the same as the people in attendance on Tuesday. Mr. Prosecutor, the prosecutor. Good morning. The OTP is represented by the team. Mr. Ido Duke, Associate Trial Lawyer, is one additional. I myself, I am back after a short absence. The presiding judge, thank you very much. Legal representatives of victims, Ms. Masida. Ms. Masida, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman, good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade Your Honours that Mr. Rodrigo Duterte should not remain in detention for years to come simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. The prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the deputy prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the deputy prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the deputy prosecutor read from this speech. So that police is under the DILG, So I have to believe the story of the police, for simply, they are my subordinates, and I am ultimately responsible for their deeds. Now let's look at what the Deputy Prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, "But if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility." Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: "I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat again for all and for everybody's consumption. Do not kill if you are not in danger of losing your life." Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact, the majority of these speeches, I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask your honors and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had a speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw your Honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting 2 alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pretrial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. The pretrial chamber, this same pretrial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in El Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the El Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pretrial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you? It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorizing an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b). But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that their cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in the document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents are not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability leveled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty which reaches more than a substantial degree of certainty is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses. Or witnesses. Where are they? Number one. Interviewee: at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer. Yes, sir. Interviewer 1. Okay. And on those 10 occasions, was the shooting justified? Interviewee: yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one. Witnesses who said, the PNP never said kill those people. Another quote. From what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication. And that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Death Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated
he stated the following.
Pagka bumunot, patayin mo. Pag hindi bumunot, patayin mo rin. Oh, para matapos na. Kasi mawala pa bro. Ako na ang bahala sa inyo. Itaga ninyo ito sa puso ninyo. For as long as I am the president. Nobody but nobody, no military man or policeman will go to prison because they perform their duties well. Ako ang mapakulong sila. Sabihin mo lang, utos ni Mayor yun.
So that was Mr. Duterte's message to the military and to the police. Kill, whether or not your target pulls a gun, and I will protect you. And Your Honours, as we will now hear, during the same speech, in case there was any doubt, Mr. Duterte made it very clear that this promise of protection related not only to lawful killings.
For as long as there is that power to pardon sa Constitution, yan ang weapon ko against crime. Magmasakir kayo ng 100, di ba, 100 rin kayo, edi pardon lahat eh. Restored to full political and civil rights plus a promotion to both. Problema niya ay yung mayor ng Albuera. Mabuti, nakaabot siya doon kay Bato na pinahanap ko, shoot on sight. Parang aso. Eh, ang tingin ko talaga sa inyo, kayo, parang aso. Tatawagin ko yung mga mayor, ilak ko, no, kami-kami lang. Sabihin ko talaga sa kanila. Ayun, ganun kakapal yung pinakita ko sa inyo eh. Hanapin mo yung pangalan mo dyan, Mayor. Pag nandyan yung pangalan mo, may problema. Talagang papatayin kita.
Let's play the video.
Wala akong ako talaga ang walang akong maipagyabang. Kaya ginadaan ko na lang sa extrajudicial killing.
Please play the clip.
Ako po'y galit.
The fourth supposed indication
Pati
of a
yung
common
mga
criminal
pulis dito
plan.
sa Maynila,
And that is set out in
nakasabit sa
paragraph
droga.
27.
Ako po'y
It mentions
nakikiusap.
That on the very day
Ako kayong
that the
pumasok
former
dyan
president appointed
kasi papatayin
Ronald
ko
de la
talaga
Rosa
kayo.
Bato
4-7.
as the chief of Philippine National Police.
Yung namatay
De La
daw
Rosa
kanina
issued
sa
a
Bulacan
pre-drafted
32.
command circular
Yun yung massive raid.
number 16 of 2016 on 1st of
Makapatay lang tayo
July
ng
that year,
another
formally
32 every
launching
day, then maybe we
the
can reduce
anti-illegal
the
drugs campaign
what is this
nationwide
country.
in express pursuance of Duterte's campaign
Yung mga
promises.
adik ho dyan, kayo na lang ho ang pumatay.
There is no dispute
Kung anak niya,
that CMC number 16
ikaw ang
of
pumatay.
2016
Anak niyang adik,
mentions
kayo ang
Project Double
pumatay
Barrel,
para hindi
which was
masyadong
indeed
masakit.
modeled
Let's
after
play that
Davao
clip.
City's policing strategy and was
Sabihin ko sa
directed
inyo,
at the
itong mga panahon
neutralization
itong mga araw
of
dadating,
illegal drug personalities
kung may
nationwide.
punerarya ho kayo,
But
kikita
here
kayo
we
ng
come to
gusto.
the crux of the prosecution case. The manifestation of the
Kayo
criminal
kayong mga
plan
small time na
in writing.
punerarya dito, doon.
Neutralization as a euphemism for murder. Ms. Robin Croft certainly thought so when making her submission on behalf of the prosecution, highlighting the word in bright red and presenting us with a slide where the word neutralization forms an integral element of the common plan. To import an element of criminality into what would otherwise be a perfectly anodyne legal document, the prosecution resorts to relying on speeches and interviews given by Ronald de la Rosa, Bato, within a day or two of him being appointed the chief of Philippine National Police. For example, in an interview relied on by the prosecution at footnote 136 of the pre-confirmation brief, De La Rosa explains how tok hang means knock and plead, and that it is a totally legitimate police strategy. However, the citations relied on by the prosecution to infer that tok hang was a criminal modus operandi are completely taken out of context. I shall just cite one question and answer from the media interview on which the prosecution relies at paragraph 27 to prove that De La Rosa, when talking about instilling fear in the hearts of drug users, was actually proposing a policy which was anything but criminal and totally supportive of the main tenet of the defense, namely that the only use of force would be that envisaged by way of self-defense. And I quote, question, "Sir, you mentioned about instilling fear. When you instill fear, how do you ensure that you do not violate human rights?" Answer, good question. We will see to it that the police operational procedures are being followed in every legitimate police operations. When they see that the police are really determined to go for them legally, he stresses the word, and many of them go down, maybe they'll get scared. That's PHL, OTP 000-16403 at page 13. In any event, what the prosecution has not told you, and what it has not shown you by way of its opulent images on the video screen, is that the supposed criminal blueprint set out in Command Circular 2016, number 16 of 2016, is totally negated by the content of the document itself. Let us take a look at paragraph 8E and F of the very same Command Circular, number 16 of 2016, which states quite clearly that all operations should strictly observe the rights of the accused enshrined in the Philippine Constitution, as well as international law and human rights. Why, I ask you, did Mr. Edward Jeremy, counsel for the prosecution, in his very eloquent and gilded address, not screen this part of the Command Circular? After all, this Command Circular, as elaborated by Ms. Robin Croft, was the very essence of his criminal common plan, in writing. This is the basis, so Mr. Jeremy stated, for the criminal agreement to kill high-value targets. And if that were not enough, the lawfulness of Command Circular 16 of 2016 was reiterated 3 weeks later on 22 July through the initiation and issuance of PNP Investigative Directive number 12 of 2016, which set out additional policies and guidelines in the conduct of double barrel. I think there, Madam President, if I may, we can take a break, obviously with your permission.
Bien sûr, maître, je vous remercie, Kaufman, je vous remercie beaucoup.
Thank you, Counsel. Thank you very much. If you can also indicate the numbers of the documents that you have referred to, that will be good. Thank you very much, says Judge Motok. We will take a break now and resume at 11:30. Thank you very much.
He stated the following.
Pagka bumunot, patayin mo. Pag hindi bumunot, patayin mo rin. Oh? Para matapos na. Kaysa mawala pa bro. Ako na ang bahala sa inyo. Itaga ninyo ito sa puso ninyo. For as long as I am the President. Nobody but nobody, no military man or policeman will go to prison because they perform their duties well. Ako ang mapakulong sa ito. Sabihin mo lang, utos ni Mayor yun.
So that was Mr. Duterte's message to the military and to the police. Kill, whether or not your target pulls a gun, and I will protect you. And Your Honours, as we will now hear, during the same speech, in case there was any doubt, Mr. Duterte made it very clear that this promise of protection related not only to lawful killings.
For as long as there is that power to pardon sa Konstitusyon, yan ang weapon ko against crime. Magmasakir kayo ng 100, di ba? 100 rin kayo, di pardon lahat eh. Restored to full political and civil rights plus a promotion to both. Problema niya ay yung mayor ng Albuera. Mabuti, nakaabot siya doon kay Bato na pinahanap ko, shot on sight. Parang aso. Eh, ang tingin ko talaga sa inyo, kayo, parang aso. Tatawagin ko yung mga mayor, ilak ko, no, kami lang. Sabihin ko talaga sa kanila. Ayun, ganun kakapal yung pinakita ko sa inyo eh. Hanapin mo yung pangalan mo dyan, mayor. Pag nandyan yung pangalan mo, may problema. Talagang papatayin kita.
Let's play the video.
Wala akong ako talaga ang walang akong maipagyabang. Kaya ginadaan ko na lang sa extrajudicial killing.
Please play the clip.
Ako po'y galit. Pati yung mga pulis dito sa Maynila nakasabit sa droga. Ako po'y nakikiusap, wag ho kayong pumasok dyan kasi papatayin ko talaga kayo.
4-7.
Yung namatay daw kanina sa Bulacan 32, yun yung massive raid. Ganda yun. Makapatay lang tayo ng mga another 32 every day, then maybe we can reduce the what ails this country.
Now.
Ay, yung mga adik ho dyan, kayo na lang ho ang pumatay. Kung anak niya, ikaw ang pumatay. Kung anak niyang adik, kayo ang pumatay para hindi masyado masakit.
Let's play that clip.
Sabihin ko sa inyo, itong mga panahon nitong mga araw na dadating, kung may punerarya ho kayo, kikita kayo ng husto. Tayo ko yung mga small time na punerarya dito, doon. At sigurado hindi kayo malugi. At pag humihina na ang negosyo ninyo, sabihin ko lang sa mga pulis, bilis-bilisan ninyo ng konti para kumita yung tao sa negosyo nila. Ayan, sinasabi ko na sa inyo.
Ikalawang sesyon na ng confirmation hearing kay dating Pangulong Rodrigo Duterte. Alamin po natin ang nangyayari doon ngayon. Live mula sa The Hague, Netherlands. Nasa frontline ng balitang yan si News 5 anchor Angela Lagunzad Castro. Angela, sinong panig naman ang nagsasalita sa ikalawang sesyon ngayon?
Julius, sa aking pag-alis kanina, prosecution pa rin ang naglalahad ng mga ebidensya tungkol nga dito sa confirmation of charges si Pangulong Rodrigo Duterte. At isa sa mga highlights kasi ang key highlights nga ng presentation today ng prosecution ay mga videos and audio presentations na mula mismo sa kay Duterte. Kumbaga si Duterte ang nilalaman nitong mga videos na ito. So pinakita dito sa korte yung paglabas si dating Pangulong Rodrigo Duterte ng photo gallery na naglalaman ng mga individual na kumbaga sabi nga nila high value target. At sinabi ng prosekusyon kapag ikaw ay nandoon sa listahan na yon ay karaniwan namamatay. So binanggit nila yung pagkakataon na isang high profile case na namatay na nandoon sa photo gallery na yon tulad na lamang nitong si Albuera Leyte Mayor Rolando Espinosa Jr. Namatay siya, siya ay naunang sumuko pero napatay sa loob ng kanyang selda kasama ang isang Raulyap. At of course, sa opisyal na ulat, sinabi shootout daw yun, Pero lumitaw sa ebidensya na sinadya silang pinatay sa isang multi-agency coordinated operations, So ilang ulit pinakita ng prosekusyon ng iba't ibang mga videos, katulad na lamang ng pagsabi ni former President Rodrigo Duterte na kapag nanlaban, barilin ninyo. Kapag hindi bumunot ng baril, barilin nyo pa rin. So, ilan lamang yan dun sa mga videos na ipinapakita dito ng prosecution para idiin mismo si Pangulong Rodrigo Duterte sa mga kaso niya. Julius.
Maraming salamat, Angela Lagunsad Castro.
Bago pa man ilatag ang mga dagdag na ebidensya tungkol sa Duterte drug war, una nang hinimay ng prosekusyon ang mga patayan sa Davao City noong mayor pa si dating Pangulong Rodrigo Duterte.
Ipinarinig sa korte ang mga pagmumura ni Duterte sa ICC at ang pag-utos niya noon na pumatay. Ayon sa prosekusyon, si Duterte ang kumumpas sa Davao Death Squad o DDS. At live mula sa The Hague, Netherlands, nasa frontline ng balitang yan si Angela Lagunsad Castro. Angela, ano-ano na ang mga bagong tinalakay ng prosecution dyan?
Cheryl and Julius, tama kayo, nandito pa rin ako dito sa area ng Media Center ng ICC sa The Hague, Netherlands, kung saan ongoing po ngayon yung second day ng hearing or confirmation ng charges ni Pangulong Rodrigo Duterte. Dito inilahad muli ng prosekusyon ng iba't ibang mga ebidensya para magpatibay doon sa kanilang kaso laban kay Pangulong Rodrigo Duterte. At dito nga binanggit nila kung ano yung Oplan barrel project ng PNP during the Duterte administration. Nabanggit din nila yung narco list or so-called PRRD list. At mamaya, hima-himayin natin yan maya-maya lamang. At kahapon nga, inilatag ng prosekusyon ng ilang ebidensya laban kay Duterte, kabilang ang Davao Death Squad.
Pagkita ni Esa Rosales. Kawana. Sabihin na lang ngayon. Kawana. Tulog. Tanong lang sa mga tao.
Kahapon, inilatag ng prosekusyon ang ilang ebidensya laban kay Duterte, kabilang ang Davao Death Squad. Ipinanood sa confirmation hearing ang CCTV ng pagpatay sa 3 hinihinalang magnanakaw sa Agdao Public Market sa Davao City sa katirikan ng araw noong December 2013. Maririnig sa background si nooy Davao City Mayor Rodrigo Duterte. Ayon kay ICC Senior Trial Lawyer Julian Nichols, 3 hitman ng Davao Death Squad o DDS ang nagtumba sa mga umano'y magnanakaw. Sa structure ng DDS, pinakamataas daw si dating Pangulong Duterte na siyang naguutos at nag-a-approve ng mga pagpatay. Iniuutos naman ito ng kanyang co-perpetrators o kasabwat sa DDS handler hanggang sa umabot sa mga hitman.
DDS members did not fear punishment because they were committed at Mr. Duterte's orders or direction.
Nagpresenta rin ang prosekusyon ng mga video at pahayag noon ni Duterte na inamin niyang mayroon ngang Davao Death Squad, kabilang na ang pag-amin niya noon under oath sa Senate Blue Ribbon Committee.
So that is 4 times, 3 of them under oath, that he admitted having a death squad in Davao, including saying he is the death squad. That's not hyperbole. That's not bluster. That's him telling the truth, and he feels safe.
Binanggit din ng prosekusyon ng co-perpetrators o kasabwat ni Duterte, kasama sina Senator Bato de la Rosa, Senator Bongo, dating Justice Secretary Vitaliano Aguirre II, dating Davao City Police Chief Vicente Danao at dating NBI Chief Dante Gueran. Ipinakita rin ang lumang larawan ni Duterte na may hawak na assault rifle. Kasama niya rin si De La Rosa na kalaunay naging PNP Chief at si Isidro La Peña na itinalaga noon ni Duterte bilang Director ng Philippine Drug Enforcement Agency o PDEA. Patunay raw ang litrato na tough guy ang gustong ipakitang imahe ni Duterte. Nang mahalal na Pangulo, ginawa raw nationwide ni Duterte ang operasyon ng Davao Death Squad. Nabanggit na raw noon ni Duterte na siya ang aako ng responsibilidad sa madugong drug war.
That's the man before you for this hearing, even if he's not in court today. He repeatedly promised to kill people, his own people, if elected president. He said it, he did it, that's who he is.
Ilang araw bago maaresto, nakuha pa nga raw murahin ng dating Pangulo ang ICC, pero pagdating sa The Hague,
of course, after arriving in the Hague, his lawyers very soon began arguing that Mr. Duterte was not fit enough for these proceedings.
biglang hindi na raw fit to stand trial si Digong kahit na napatunayan ng mga medical expert ng ICC na physically at mentally fit ang dating Pangulo. Bago ang presentasyon ng prosekusyon, giniit ng abogado ni Duterte na si Attorney Nicholas Kaufman na totoong hindi fit to stand trial si Duterte. Apela ni Kaufman sa ICC, ibasura ang mga alegasyon dahil wala niya itong sapat na ebidensya at bunga lang ng pamumulitika.
We will ask you to send Rodrigo Duterte back to his family, and we will ask you to give back to the Filipino people their Tatay Digong.
So dito nga sa ongoing na day 2 no ng confirmation of charges ni Pangulong Rodrigo Duterte ay pinupunto ng prosekusyon yung direct involvement ni dating Pangulong Rodrigo Duterte dito sa narco list o yung so-called PRRD list no at ipinakita nila ang isang video na nagsasabi nga no and I quote, the one reading, sabi niya, the sole responsible, a sole person responsible. Yung sa pamamagitan ng video na ito, si Pangulong Rodrigo Duterte ang nagsasabi noon at claiming na siya ay responsable doon sa narco list. Dito sa list na ito, pinakita ang isang Excel spreadsheet na may mga photo ng mga ilang mga individual na may pangalan, kung saan man silang region, no, kinabibilangan at bawat pangalan doon, Cheryl and Julius, ay may naka-assign na difficulty level or different level rather. No? Una, yung mga lower level lamang na mga police or street level users, yung mga pag nasa 5 level ka na o 5th level ka na, high value target naman ang mga nandoon, ano, yung mga tulad ng drug financiers, mga high-ranking police officials. So sabi daw ng insider ng witness ng prosekusyon, ang itong list na ito ay ginagamit ng mga police kung nasa listahan ka, subject ka, or most of the time, kasama ka sa papatayin. Julius and Cheryl.
Angela, matapos nga itong unang araw ng confirmation hearing ni former President Duterte, may balita na ba tayo tungkol sa kanya? Meron na bang nakakausap sa kanya or mismong yung kanyang lawyer na si Attorney Kaufman?
Yeah, Cheryl, kanina no, we were able to talk to Attorney Kaufman sa labas dito bago siya pumasok sa ICC court. Na-ambush interview natin siya at tinanungan natin siya kung nakausap ba niya si Pangulong Rodrigo Duterte pagkatapos ng confirmation of charges kahapon. Sabi niya, oo naman daw. Nagbigay siya ng update at tinanong natin kung ano naman ang naging kumbaga pahayag ni Pangulo. Ang maikli lamang yung sinabi ni Kaufman dito, ang sinabi niya, he is happy. When we pressed na anong klaseng happy, bakit happy, ganito, sabi niya client lawyer privilege na lang ang sinabi niya sa atin. But he made sure na sinabi nga niya sa atin na nagkausap sila ni President Rodrigo Duterte.
Angela, meron na bang ine-expect na ipipresent na testigo ngayon ang prosekusyon?
O Cheryl, kasi nga dahil hindi pa ito ang aktual na trial, this is just a pre-trial. Pagdedetermina kung meron bang sapat na ebidensya ang prosekusyon para i-move forward sa full trial itong kaso. So wala muna tayong makikitang mga witnesses, live witnesses dito. Meron ipepresenta ang prosekusyon ng mga dokumento, audio and video presentation, pero walang mismong witness. Tapos pinagbawal din according sa House rules ng pre-trial chamber. Kahapon sinabi yan, bawal din magbanggit ng mga pangalan ng witnesses, bawal divulge yung kanilang mga identity. Kung kinakailangan ito sa pagpresenta, ito ay pag-uusapan muna in a private session. Doon pagdedesisyonan kung pwede ngang sabihin during the hearing. Pero so far, yun lang po, wala tayong aasahan na live witness na ipepresenta ng prosekusyon dito nga sa ongoing na confirmation of charges. Cheryl.
Angela, kahapon nakita natin na in-establish ng prosekusyon yung sinasabing systematic at organized na mga patayan ng mayor pa ng Davao City si dating Pangulong Duterte. Ngayon ba ay may mga ipepresent pa sila mga karagdagang ebidensya na magpapatibay dito para matalakay na rin kung sino yung mga co-perpetrators o kasabwat daw ng Duterte drug war?
Yun, Julius, yung mga pinapakita ngayon kasalukuyan ng prosecution sa confirmation of charges dito sa ICC court, pre-trial chamber, yung mga memorandum about Oplan na double barrel, itong mga so-called narco list, yan yung mga sinasabi ng prosecution dito kasi sa ICC, Julius and Cheryl, may different modes sila ng criminal liability, sinasabi dito, it's either your direct perpetrator or indirect perpetrator. Ang pinupunto ng prosecution dito ay yung pagiging indirect perpetrator ni Pangulong Rodrigo Duterte na merong mental involvement si Pangulong Rodrigo Duterte. Hindi man siya ang humawak ng baril para patayin ang isang individual, pero siya mismo ang nag-utos at may kinalaman dito sa tinatawag nga nila na war on drugs. So yun yung ilang mga ebidensya na ipinipresenta ngayon kasalukuyan dito sa confirmation of charges.
Maraming salamat, Angela Lagunzad Castro, live mula sa The Hague, Netherlands.
Inisa-isa ng prosecution sa confirmation of charges hearing ni dating Pangulong Duterte ang mga kasabwat umano ng dating Pangulo. Kabilang po dyan si Senador Bato de la Rosa at Senator Bongo. At live mula sa Senado, nauna sa balita si Camille Samonte. Camille, anong reaksyon ng mga nabanggit sa pagdinig?
Bok, nakipag-ugnayan tayo dun sa 5 co-perpetrators umano ni dating Pangulong Rodrigo Duterte para sa kasong crimes against humanity na binanggit sa confirmation of charges hearing kahapon. Tanging si Senator Bongo lang ang sumagot sa isang ambush interview kanina. Naging matipid ang sagot ng senador. Tumagi siyang magkomento at ang sinabi niya lang ay hintayin na lamang daw munang matapos itong confirmation of charges hearing ni dating Pangulo ngayong linggo. Pakinggan natin ang pahayag ng senador.
Same statement po ako. Same statement po.
Which is?
Yung ano yung sinabi ko noon, ganun pa. Antayin na lang natin matapos yung information.
Nauna nang itinanggi ni Go na may kinalaman siya sa mga pagpatay sa war on drugs. Wala rin daw basehan at unfair ang pagkakadawit sa kanya. Samantala, yung iba pang 4 na co-perpetrators na pinangalanan na sina Senator Bato de la Rosa, dating Davao Police Chief Vicente Danao, dating NBI Regional Director Dante Giran at dating Justice Secretary Vitaliano Aguirre ay wala pang sagot ng hingan natin ng pahayag. Bok?
Okay, Camille, balikan lamang natin. Ano ba ang sinabi ng prosecution kahapon tungkol dun sa mga co-perpetrators?
Bok, ayon sa prosecution, tinulungan ng mga co-perpetrators si Duterte sa operasyon na binuo nito ng grupong Davao Death Squad. Ipinakita rin ng prosecution yung chain of command ng grupo at papel ng mga kasabwat para gawin ang mga pagpatay. Narito ang paliwanag ng prosecution.
And it had a hierarchical pyramid-like structure. At the very top, as mayor, Rodrigo Duterte. Under him were co-perpetrators, just some of whom I have mentioned. The co-perpetrators had different roles, but one of them was to relay orders and instructions down from Mr. Duterte to the DDS handlers, and also to relay reports back up to Mr. Duterte.
Bok, sa mga oras na ito ay nagpapatuloy na yung pagdinig sa ICC at tinatalakay na nga itong mga partikular na naging papel ng mga kasabwat para magawa ang krimen. At partikular na na-mention dyan, Bok, ng prosecution, itong first na memorandum circular na inilabas nung kahahalal lamang nito ni Senator De La Rosa bilang PNP chief na pinangalanan nga na Project Oplan Barrel. At kaugnay niyan, may lumabas din na pinakabagong survey ang SWS na kung saan nagsasabi na 53% ng mga Pinoy ang nagsabi na sang-ayon sila na dapat papanagutin si Senator De La Rosa sa mga pagpatay. 44% naman ang nagsabi na dapat ikulong si De La Rosa sakaling maglabas ng bagong warrant of arrest ang ICC. Wala pang tugon dyan si De La Rosa na hanggang ngayon ay hindi pa rin nagpapakita sa Senado simula pa noong Nobyembre noong isang taon. Yan muna ang latest. Balik sa iyo, Bo.
Ulat ni Camille Samonte live mula sa Senado. Balikan natin ang ulat ni mobile journalist Julie Baiza tungkol sa reaksyon ng Malacanang sa mga pahayag ng abogado ni Duterte laban kay Pangulong Bongbong Marcos. So, Julie, ano ang sinabi ni Attorney Nicholas Kaufman at ano naman tugon ng Malacanang?
Bok, balikan nga natin yung sinabi ni Attorney Nicholas Kaufman sa ICC kahapon. Sa kanyang opening statement sa pre-trial chamber, pinagkumpara niya yung estilo ng pamumuno ni Pangulong Bongbong Marcos at ni dating Pangulong Rodrigo Duterte. Si dating Pangulong Rodrigo Duterte raw, sinsero at may isang salita, habang si Pangulong Bongbong Marcos tila or pawang nagsasalita raw sa hangin. Ang inihalimbawa ni Kaufman ay yung sinabi daw ni PBBM noon na hindi makikipagtulungan ang pamahalaan sa ICC sa anumang paraan. Pero nung naaresto daw si dating Pangulong Duterte, ilang ulit daw itinanggi ng administrasyon na may alam or nakikipagtulungan at wala silang kinalaman sa pag-aresto sa dating Pangulo. Taliwas daw yan, Bok, doon sa nakuha nilang phone transcript. Narito ang pahayag ni Attorney Nicholas Kaufman.
One of these parties was boasting about how he was acting as the silent partner of President BBM, managing a scheme to funnel witnesses to this court while all the time ensuring that he could guarantee President BBM's plausible deniability. So it is indeed the defense case that President Ferdinand Marcos Jr. set out to neutralize Rodrigo Duterte and his legacy.
Bok, hindi naman pinalampas ni Palace Press Officer Undersecretary Claire Castro yung pahayag niya ni Kaufman sa panayam ng One Balita Pilipinas ng 1PH. Sinabi ni Castro na hindi totoo na planong inutralize ni PBBM ang legacy ni Duterte. Gawain daw yan ni Duterte. Pakinggan natin ang pahayag ni Palace Press Officer Claire Castro.
Ang dami niyang ni-neutralize patungkol sa media na mga di umanong karibal niya sa politika. At isa ng ebidensya dito ng pag-neutralize. Inamin mismo ni Mayor Magalong na siya ay oversight committee head ng Tokhang. Umamin siya na base sa kanyang report, kung meron man, ay maraming pinatay sa panahon ng EJK nang walang basihan.
Bok, nagkomento rin si Yusek Castro doon sa sinasabing nakuhang transcript o phone transcript ng pag-uusap umano ni PBBM at ng isang silent or tinawag niyang silent partner. Narito yung pahayag ni Yusek Castro.
Una pinabubulaanan yan. Pangalawa, ano to, anti-wiretapping? Gumagawa na naman ba sila ng illegal? Sanay na sanay silang gumawa ng krimen? Walang katotohanan yung sinasabi na niyang yan. Ito'y gawa-gawa lamang at para mailihis yung issue ng pagpapapatay, yung karumal-dumal at madugong extrajudicial killings na ginawa.
Okay, Julie, anong reaksyon ng palasyo sa sinasabi ni Kaufman na walang isang salita si Pangulong Marcos tungkol sa pakikipagtulungan ng gobyerno sa ICC?
Bok, sa programang Good Morning Kapatid, sinabi ni Yusek Castro na inililihis lang daw ni Kaufman yung usapin. Ang usapin daw dito, yung crimes against humanity ni dating Pangulong Rodrigo Duterte at hindi si Pangulong Bongbong Marcos. Narito muli ang pahayag ni Yusek Castro.
In the first place, parang wala siyang dininay doon sa mga akusasyon kay dating Pangulong Duterte. Pinapahid na lang niya doon sa ginawa di umano ng administrasyon para ma-surrender ang dating Pangulong Duterte doon sa ICC. Hindi yun ang usapan eh. Ang usapan, yung patayan. Yung mga magkakasabwat kayo di umano para dito gawin isang common plan na pumatay.
Okay, Julie, maiba naman tayo. Anong sabi ng palasyo sa pahayag ni Atty. Harry Roque na gusto raw makipag-ayos ng Pangulo kay VP Sara Duterte pero ang tumanggi raw ay yung bise?
Bok, sabi ni Yusek Claire, sinungaling at saka parlor talk lang daw yung sinasabi ni Harry Roque, ni Atty. Harry Roque, no? Problema rin daw kasi kay VP Sara, palagi siyang naniniwala sa mga, sabi ni Yusek Claire, kwentong barbero ni Harry Roque na ang sabi pa niya, source naman daw ng fake news. Yung pagtanggi naman daw ng bise na pakikipag-ayos sa Pangulo, pagpapakita lang daw ng kanyang tunay na kulay. Bok.
Okay, Julie, in the past 4 days, 2 beses nakapagkita sina Pangulong Marcos at si Naga City Mayor Leni Robredo. Una sa Naga City at sunod naman kahapon dun sa Malacanang. May kinalaman ba ito sa 2028 elections?
Bok, muling iginiit nga ni Yusek Castro na wala daw talagang bahid ng politika yung naging pagkikita. Ang ilang ulit daw na pagtatagpo, patunay lang na pareho na silang mahusay magtrabaho. Pinapakita rin daw ni Pangulong Bongbong Marcos ngayon na walang kulay yung politika, walang kulay ng politika yung kanyang pamumuno. Yan muna ang latest. Balik sa Bok.
Ulat ni Mobile Journal Julie Baiza, live po mula sa Malacanang. Sa puntong ito mga kapatid, alamin natin ang update sa confirmation of charges hearing ni dating Pangulong Duterte sa ICC. At live po mula sa The Hague, Netherlands. Noong sa balita si News 5 anchor Angela Lagunzad Castro. Angela, ano na ang tinatalakay ngayon sa day 2 ng pagdinig?
Hi, Bok. Tama ka, nandito pa rin ako sa ICC para nga sa confirmation of charges ni Pangulong Rodrigo Duterte. At of course, ngayon 32 minutes pa lang ang natatapos. 32 minutes pa lang ang natatapos ang nagagamit para dito sa sa nangyayaring confirmation of charges at doon tinalakay ang mga bagong ebidensya na pinresent ng prosecution. Doon pinakita yung sinasabing the so-called PRRD list or narco list kung saan merong pinakitang spreadsheet doon na may mga personalities at binanggit din doon sa kanilang mga presentasyon na lahat daw ng mga binanggit doon sa mga narco list ni Pangulong Rodrigo Duterte ay namamatay. Kasama na sa mga binigay na example ay yung sila Reynaldo Parahinog at saka sila Espinosa. Tapos ay pinakita rin doon sa mga may mga video clips mula sa mga news organization ay pinakita ang prosecution tungkol doon sa mga pagmumura ni Pangulong Rodrigo Duterte at pagpapakita niya mismo nitong narco list itong Excel spreadsheet at meron pang mga parang ang sinabi niya sa media na itong mga human rights na ito, may pagmura siyang sinabi doon at sinabi niya papakain ko tong papel na to sa kanila. Ilan lamang yun, Bok, dun sa mga ipinresenta ngayon. Lumabas muna ako para makapagkwento sa'yo. So, yun muna, Bok.
Okay, Angela, kahapon nagkaroon ng pagkakataon ng depensa na magsalita at ginit nila na inosente si dating Pangulong Duterte. Ano namang reaksyon ng kampo ng mga biktima?
Sa programang Sa Totoo Lang ng 1PH, sinabi ni Atty. Nery Colmenares na abogado ng drug war victims na nagulat sila dahil basic daw ang inilatag na depensa ng Duterte camp. Niwala nga raw ebidensya para i-counter ang mga alegasyon ng prosekusyon at hindi raw maituturing na depensa ang sinasabi ni Atty. Nicolas Kaufman na hyperbole or exaggeration lamang ang mga sinabi noon ni Duterte tungkol sa mga pagpatay. Pakinggan po natin ang pahayag ni Atty. Colmenares.
Nagulat kami kasi napaka-basic ng depensa na yan. Yung hyperbole kasi o joke, Pag walang namatay, pwede nga sabihin, joke nga lang yan, tawanan tayo. Pero ang problema ni President Duterte, matapos siya mag-hyperbole at matapos siya mag-joke, libo-libong namatay. Hindi ko alam kung makumbinsin nila ang korte, pero I think maraming Pilipino hindi makumbinsin na wala siyang intensyong pumatay.
Well, Angela, kahapon sinasabi ng kampo ng mga biktima na merong virus of impunity na kumakalat sa bansa dahil kay dating Pangulong Duterte. Anong reaksyon dito ng kampo ng dating Pangulo?
Well, Bok, sa panayam sa programang The Big Story ng One News, may reaksyon dyan si Atty. Salvador Panelo na dating Chief Presidential Legal Counsel ni Duterte. At ayon nga sa kanya, repetitive propaganda ang mga sinabi ng prosekusyon at kampo ng mga biktima laban kay Duterte. Speculation at hearsay at hindi suportado ng ebidensya. Nasagot din daw ni Atty. Kaufman ang mga ibinato ng prosekusyon at bumwelta rin itong si Panelo sa sinabi ni Atty. Joel Butuya na kumakalat umano ang virus of impunity sa bansa. Pakinggan po natin ang naging pahayag ni Atty. Panelo.
Yung sinasabi niyang virus of impunity, I think he's referring to the virus of lies that they and he, people like him, have propagated all these years against the former president. Silang kailangan bakunahan ng katotohanan.
Angela, nakausap mo ba ang defense team matapos ang unang araw ng pagdinig? Kamusta raw ang dating Pangulo?
Well, kanina nakausap nga natin bago tayo pumasok dito sa media center si Attorney Nicolas Kaufman at natanong natin kung nakausap nga ba niya si Pangulong Rodrigo Duterte at sabi nga niya masaya raw si Pangulong Duterte sa naging takbo ng pagdinig kahapon. Pakinggan po natin ang pahayag niya.
I can assure you that he's extremely happy with the way things are going at the present moment in time. He is always good spirits. He's an 8-year-old man. He has all the conditions which one would expect of an 8-year-old man, with the extra conditions which accompany his cognitive state.
So, hindi magsasalita today ang defense pero examine daw nila ang ebidensya. Siyempre kasi ang pagkakataon nila para makapagsalita ay sa Thursday pa. No? So, hindi raw irrelevant sa kaso. Actually, natanong ko rin ito nung nakausap ko si Atty. Kaufman kanina na sinabi ko ano yung masasabi niya doon sa sinabi ng iba katulad na lamang ni Atty. Nery Colmenares sa hanay ng mga biktima na sinasabi nila wala namang basihan at irrelevant yung pagbanggit niya o pag-involve niya kay Pangulong Bongbong Marcos sa kanyang opening statement yesterday. At of course, sabi niya ay irrelevant, relevant naman daw itong pagbanggit niya kay Bongbong Marcos dahil nga sa kanilang ebidensya na pinupunto ay si President Bongbong Marcos nga daw ang gagastos at nagpaplano nitong mga kaso dito sa ICC. Of course, appeal to emotion statement niya yesterday dahil pinasikat daw na Pangulo ito ng Pilipinas. So hinihintay pa raw nila ang desisyon sa challenge nila kaugnay ng jurisdiction ng ICC. So yan muna ang latest dito. Balik sa iyo, Bok.
Ulat ni Angela Lagunzad Castro, live po mula sa The Hague, the Netherlands.
Ilang oras na lang at magsisimula na nga po ang ikalawang araw ng confirmation hearing ni dating Pangulong Duterte sa ICC. Makibalita tayo sa sitwasyon doon mula sa The Hague, the Netherlands. Nasa linya ng telepono si Angela Lagunzad Castro. Angela, anong oras na ba dyan ngayon at ano ang inaasahan natin ngayong ikalawang araw ng hearing?
Hi Ruth, it's actually 7:39 in the morning here in The Hague, Netherlands. At tulad nga ng nasabi mo, natuloy na kahapon ang confirmation of charges hearing ni dating Pangulong Rodrigo Duterte sa ICC matapos nga 5 buwang pagkakadelay. So ngayon Ruth sa pangalawang araw ng confirmation of charges ni dating Pangulong Rodrigo Duterte, ay aasahan po natin ang pagpapatuloy ng submission on the merits ng prosekusyon at ng panig ng mga biktima sa pamamagitan ng kanilang legal counsel. Ang ibig sabihin nito ay maglalabas pa ng iba't ibang ebidensya ang dalawang kampo upang pagtibayin ang kaso laban kay Duterte. Kumbaga, hindi na lang usapin ngayon yung kung ano ang sinabi, kung ano-ano ang nangyari at kung di kundi kung ano ang nangyari at kung may sistemang nagpapatupad nito. Mula sa maanghang na mga pahayag, ngayon susuriin kung may mga konkretong mekanismo nga ba sa likod ng mga operasyon, no? Kaya ang tanong ngayon, may ebidensya ba na ang mga salita ay naging aktual na polisiya? Ano ang mga naging resulta ng mga naging pahayag ng dating Pangulo? Yan yung isa sa mga ilan pa sa mga alamin natin mula kahapon. Yan ang karagdagang ilalabas pa ngayon at aabangan uli natin mula sa prosekusyon at mula sa mga biktima. Ganun pa rin ang oras, Ruth, 10 a.m. to 3 p.m. The Hague time ang simula ng confirmation of charges dito. At dyan sa Pilipinas naman magsisimula 5:30 ng hapon. Merong 30-minute delay dahil na rin sa usapin ng seguridad. So bukas naman ay nakatakda ang araw ng pahinga. Pero pagbalik sa Huwebes, February 26, dito naman inaasahan ng submission on the merits ng depensa. Ibig sabihin nito, diretsahan ng haharapin ng depensa ang mismong akusasyon laban kay dating Pangulong Duterte at hindi na ito tungkol sa technical issue, sa proseso or yung ang tatalakayin dito ng depensa at kung talaga lang na may sapat, kung may talagang kung talaga bang may sapat at matibay na ebidensya para sasabihin may krimen at pananagutan si dating Pangulo. Kumbaga, Ruth, dito susubukan ng depensang ipakita na mahina ang argumento, ang pundasyon ng mga paratang ng prosekusyon. So yan muna ang latest mula dito sa The Hague, Netherlands. Balik sa'yo dyan.
Angela, ito pa ulit-ulit namang sinasabi, even sa statements ng ICC na hindi pa ito, yung actual na trial, hindi pa ito yung magde-decide sila kung guilty o hindi ang dating Pangulo. Pero nung una kasi lumutang na posibleng may mga testigo. O mailalabas ba yan ngayon sa puntong ito na submission pa lang ng merits? Or ano ang, halimbawa, mga documents lang ba ito, mga litrato? Ano kaya yung posibleng ebidensya na makita natin?
Ako, Ruth, yan ang paulit-ulit nating kinumpirma kay Attorney Cristina Conti na talagang at this stage of the case, dahil pre-trial pa lang ito, hindi ito yung actual, wala tayong makikitang mga mismong witnesses dito, So mostly audio, video presentation, documents ang makikita natin kung, at actually sabi nga base doon sa House rules kahapon na sinabi ng pre-trial chamber ng mga judges doon, ang bawal silang magbigay ng eksaktong pangalan, identity ng mga witnesses, Yun ang sabi nila doon, unless kung kinakailangan ito ay pag-uusapan muna in a private session, tsaka nila aaprubahan kung talagang kailangan ibigay yung pangalan sa publiko. But for now, at this stage, wala tayong makikitang mga witnesses, wala tayong makikitang mga pangalan ng mga witnesses, at talagang audio, video presentation at mga dokumento, mga pictures yan ang mga makikita natin sa ngayon. So kung meron man tayong makikitang panibago dito sa aking sinabi, maaari yung pagdidesisyonan ng pre-trial chamber.
Yan pong express report ni Angela Lagunsad Castro mula sa The Hague, the Netherlands.
Sinubukan umano ni Pangulong Bongbong Marcos na i-neutralize si dating Pangulong Rodrigo Duterte. Yan ang akusasyon ng kampo ni Duterte sa pagdinig ng International Criminal Court kaugnay sa reklamong pinahaharap ng dating Pangulo. At kaugnay nga nitong balitang to, makakausap natin live via Zoom si Palace Press Officer Claire Castro. Magandang umaga po yung si Claire.
Yes, good morning Nikki at good morning sa lahat ng sumusubaybay sa inyong programa. Good morning po.
Ayun, good morning Yusek. So, malamang sa malamang, narinig nyo na po to. Sumusubaybay po kayo sa ICC hearing. Ano po bang reaksyon nyo dito nga sa pahayag ni Kaufman na meron daw pong transcript ng isang interview? Kumbaga, it was a transcript na there's like collusion daw na isinishield si President BBM about what's happening with the ICC hearing?
Unang-una, sabi nga natin, nag-react na tayo dyan. Sinabi natin parang ang nagsasuffer ng severe cognitive impairment ay walang iba kung hindi itong si Attorney Kaufman at hindi ang kanyang kliyente. Dahil matatandaan natin, ang kasong to ay crimes against humanity na sinampa pa as early as 2017. So bakit lagi niyang pinapahid kay Pangulo Marcos Jr. itong mga kaso, itong mga di umanong kasalanan ng pagpatay, ni dating Pangulong Duterte? Hindi na lang niya tutukan kung paano niya didepensahan at i-deny yung mga bintang ng pagpapatay at architect pa di umano itong si dating Pangulong Duterte, mastermind ng itong common plan among the DDS. So, hindi niya tinutukan yun eh. Instead, pumunta siya sa politika paawa, appealing to the emotions of the Filipino people. So, hindi konektado yung si Pangulong Marcos Jr. doon sa mga patayang naganap noong 2011 hanggang 2019.
Pero Attorney Claire, yun nga po yung kinuha niyang, kumbaga pinili niyang anggulo, yung political persecution. And as a trial lawyer, paano po kung may pruweba nga pong authentic ito, again, ito pong interview na ito ay galing sa, sa prosecution side. Bakit nga po ba napili itong dokumento ng prosecution to have?
Unang-una, sabi nga natin, paano niyang i-connect si PBBM doon sa mga crimes na di umanong nangyari noong 2011 to 2019. Diba? So, paano niya i-connect? Nangyari na to eh. Yung kay Pangulo, sabihin natin, ibinibintang nila, ginagawa nila na naratibo, pero that's after math na eh. Tapos na yun eh. Ang ginawa lang ng Pangulo dito at ng administrasyon ay ipatupad yung RA 9851 natin kung saan tayo ay may obligasyon din kapag ka nasa international tribunal na or state ay nag-i-start na magkaroon ng pag-iimbestiga doon, we can dispense with our own investigation here in the Philippines. So that's part of our law. And at the same time, we can also have this obligation to coordinate and cooperate with the Interpol. And we also have these residual obligations na dapat natin ipatupad base sa international law din. So, hindi siya konektado doon sa binibintang ng 2011 to 2019. So, paano niya masasabi na walang kasalanan ng Pangulo sa patayan? In the first place, Nikki, parang wala siyang dininay. Doon sa mga akusasyon, kay dating Pangulong Duterte, pinapahid na lang niya doon sa ginawa di umano ng administrasyon para mai-surrender ang dating Pangulong Duterte doon sa ICC. And that's it. Pero ang pinupukol ng prosecution ay yung patayan. Sabi nga, 20 years naging mayor. Nasa power ang dating Pangulong Duterte. Pero ang coverage lang ng hearing dyan ay mga nangyari noong 2011 hanggang 2019. So, ang hirap kasi i-connect na dinala ako dun eh. Kasalanan ni Pangulong Marcos Jr., dinala ako dun. Hindi yun ang usapan eh. Ang usapan, yung patayan. Yung mga magkakasabot kayo, di umano, para dito gawin isang...
So, the prosecution, throughout its pre-confirmation brief, invites this chamber to find, by inference, that neutralization means murder, and even carves it in stone as its formal statement of the common plan. But we, the defense, can show that the term neutralization can only mean the use of self-defense where officers' lives are endangered. For this, the text of the circular must be read in the context of the governing framework and other PNP directives. It is our submission that across the political, legislative, judicial, and law enforcement contexts, the consistent articulation has always been that neutralization denotes lawful restraint. At the executive and operational level, the Chief of the Philippine National Police, Ronald de la Rosa, Bato, publicly clarified in 2017 that neutralization means arrest. Furthermore, in an official transcript dated 28 October 2024, the former Chief of Police, De La Rosa, testifying before the Committee on Accountability of Public Offices and Investigations, testified that the term neutralization was anchored in the PNP Operational Procedures Manual, where it is specifically and strictly defined. Let us just have a look at what he said. And for your ease of reference, we will also display the said passage in the PNP Operational Procedural Manual to which De La Rosa referred, which incidentally was published in 2021. Neutralization, and I quote, "A police intervention in strict accord with the use of force continuum and/or principle of proportionality on the use of force purposely to contain or stop the unlawful aggression of the offender. This may include an arrest, capture, surrender, or other acts to subdue the suspect." It strikes us as rather mind-boggling that the prosecution should have failed to appreciate the significance of this. It was aware of De La Rosa's speech because they disclosed it to us. But the prosecution's investigators clearly never bothered to read the procedural manual to which De La Rosa was referring. In fact, we know that they didn't, because it's not on their list of evidence. Within the judicial sphere, when the terminology was examined before the Supreme Court of the Philippines, in petitions challenging aspects of the anti-drug campaign, the government defended the circulars on the basis that they did not confer a license to kill. The Supreme Court of the Philippines, however, to date, has declined to issue any ruling declaring the campaign unconstitutional, has declined to invalidate circulars, and has declined to rule to date that neutralize or neutralization means to kill. The Supreme Court's treatment of the issue is particularly instructive. The court observed that the wording was neither novel nor introduced during the Duterte administration. It had already appeared, for example, in the 2014 revised PNP Manual on Anti-Illegal Drugs Operations and Investigation. In other words, the term formed part of the existing police vocabulary. The court further clarified that the mere inclusion of the term in a circular does not render that instrument unconstitutional, especially where the circular expressly mandates compliance with internationally accepted legal principles, public policy, and the full observance of human rights, as we showed you earlier. No circular has been invalidated on this basis, nor has it ever been established at the highest level of domestic judiciary that to neutralize means to kill. The judicial record does not sustain such an equation. In each institutional setting, therefore, the term has been situated within ordinary policing powers and constrained by the lawful use of force framework. The testimonies of those operating within that framework, the prosecution's witnesses no less, are aligned with this documentary record. For example, witnesses P1158 and P1170 explained that neutralize means to arrest or to incarcerate through legal means. It did not mean to kill. Witnesses P1050 and P1174 confirmed that lethal force arose only where a suspect's resistance placed an officer's life at risk, reflecting the ordinary doctrine of self-defense and consistent with Mr. Duterte's repeated public declarations that force was justified only in such circumstances. P1214 further indicates that operational decisions were made by officers on the ground within established protocols. So,
I'm sorry to interrupt, counsel, but once again, you need to be specific and provide the document reference number. You must specify the document number, the reference number for us.
if I may, Madam President,
Merci beaucoup,
of course.
Thank you very much.
An understanding with the Learned Chamber's legal officers that we would be able to provide references after the hearing, but of course the document that I was referring to is PHL OTP 00090518-R01. So, Madam President, Your Honours, taken together, the manual, the public clarifications by police leadership, the state's position before the highest court in the Philippines, and even the prosecution's own corroborative witness testimony, all of this material demonstrates a coherent and consistent understanding that neutralization was articulated as lawful incapacitation through arrest and related measures, not as a policy of killing. And if the prosecution's case for the common plan in counts 2 and 3 is based on Command Circular number 16 of 2016, we might as well pack up and go home because Mr. Duterte is simply not guilty. However, for the sake of completeness, I continue. The fifth indicator of a common criminal plan, as alleged by the prosecution in paragraph 28 of the pre-confirmation brief, appears to be the concerted broadcasting of inflammatory speech. Here the prosecution once again selectively cites excerpts from 2016 media interviews with Ronald De La Rosa, Bato, and Vitaliano Aguirre, which suit its purpose and case theory, while totally ignoring the more unequivocal comments in those interviews which destroy its case. Regarding the interview with De La Rosa, mentioned in paragraph 28, after supposedly inciting a crowd of drug addicts to cause criminal damage to the properties of their narcotics suppliers, the newly elected chief of police states, "It's either you will die from police gunfire," and he adds, "if you resist." That's PHL OTP 00000849, page 2. Likewise, with the comments in an Al Jazeera interview, PHL OTP 00090340, comments attributed to Aguirre, from which the prosecution imputes criminality to Rodrigo Duterte by citing Aguirre's comment that the administration's policy was to stop crime and kill drug lords. Such throwaway comments reflect on Aguirre alone. And God forbid we're not alleging that Aguirre did anything wrong. Especially when, in the very same Al Jazeera interview, Aguirre states, not once, but twice, that the policy of Duterte himself was for the police to use lethal force only in self-defense. We can display that on the screen, and the part I want to read is highlighted. And President Duterte was very clear on this matter, he said, Aguirre, that there will be no killing of unarmed offenders, meaning to say that you use force only when your life is in danger. Later on, in the very same interview, Aguirre would repeat the same theme which exculpates Mr. Duterte, PHL OTP 00090340 at page 4. And I read out the relevant passage which is highlighted once again. They are supposed to arrest them, but when they fight back, then the president has instructed them that they must first protect themselves. So much for Mr. Jeremy's elastic mouth theory. Even he thought that Duterte's speech was bifurcated, and even if he did think so, his so-called perpetrators did not. So why does the prosecution cite the excerpts which support its case so selectively? Well, I'm not going to impute any malfeasance, but I can hazard a wild guess. I would suggest that the people reviewing the prosecution's massive databases for suitable evidence are performing keyword searches. Most likely, some of the most utilized operands were the words kill and perhaps sometimes neutralization or neutralize. Once the member of the prosecutor's staff has his hit, he excises the excerpt, rejoices that he can slot it into the predetermined case theory, and does not bother to read the rest of the item of the evidence, where the exonerating evidence is unequivocal. Turning to the sixth indicator of the supposed criminal plan, as set out in paragraph 29 of the pre-confirmation brief. None of the speeches imputed to the former president, nor the use of what the prosecution calls dehumanizing language, dehumanizing language by the alleged co-perpetrators suggests criminality. I would suggest that it is within the bounds of acceptable, albeit extreme political discourse, to refer to drug users in such a way as beasts, animals, or to the barangays as being plagued by the drug menace. Well, the last one is true. You can hardly expect populist politicians and law enforcement officers to refer to drug pushers and criminals as upstanding pillars of the local community. I really do feel that the prosecution is at a loss if this is its circumstantial evidence for proving the existence of a common criminal plan. The same goes for the seventh supposed indicator of criminality, which is based on the names created for the two police operations Double Barrel and Tokhang, along with their supposed evocation of firearms metaphors. While the source for this particular gem, witness P1207, a self-confessed murderous villain, might have guns perpetually on his mind and insert their imagery into his daily speech, it does not mean that those who formulated the anti-drugs policy were acting under a similar caprice when they devised the nomenclature for these two particular police operations. And of course, there were other police operations with completely different imagery, such as the one-time, big-time operation referred to by a few prosecution witnesses, and the riding in tandem operation. The mind can only boggle as to what type of nefarious imagery the prosecution believes that last title evokes. None of the indicators I have mentioned up until now have shown in any way a mutual meeting of minds between alleged co-perpetrators, evincing a communality of purpose or an agreement to act in an illegal fashion. Of course, the prosecution has shown us pictures of the alleged co-perpetrators uttering comments similar to those issuing from Rodrigo Duterte. But this does not indicate a meeting of minds, as I will elaborate shortly. The eighth factor, purportedly evincing a plan of agreed criminality, is set out or a solidarity of intent as would be required for a common criminal plan, or a common plan. Concerning and coming to the ninth category of circumstantial proof for a common criminal plan, the prosecution relies on what it believes to be the Duterte's administration's unabashed publication of statistics recording the number of deaths occasioned in the context of the so-called war on drugs. But let us just look at how and where the statistics relied upon were being published. In two government reports, the first of which being the Duterte administration's year-end report for 2017, totaling 63 pages, covering every sector of government and the economy, and of which just 2 pages are devoted to policing activities. We can give you the document ID number shortly. It's on the screen. While the deaths of 3,967 drug personalities mentioned are indeed recorded, as Ms. Robin Croft so helpfully pointed out in her presentation, and are not insubstantial, these deaths comprise a fraction of the 118,287 total arrests for drug-related activities, especially when the government is conducting special operations in a concerted drive to curb the narcotics problem. Such statistics are certainly not indicative of a wholesale policy of murder designed to supplant the process of law. If they were, then certain Latin American state parties would have regularly equaled or exceeded the Philippines in the number of law enforcement killings per capita of the population. What is quite egregious, however, regarding the prosecution's reliance on the 2017 Key Achievement Report is the way in which it glosses over, or rather ignores, those pages which do not suit its case theory. Take, for example, pages 28 of the document, which highlights the fact that 1,900 drug-related investigations had been carried out against law enforcement officers in the preceding year, with 375 police officers being dismissed, including the 2 policemen involved in the murder of Carl Arnaiz, who were later convicted and sentenced to life imprisonment. These policemen were affiliated with the Caloocan City Police Station, and where, so the report mentions, 1,000 personnel belonging to that station were sent for retraining. To conclude, this document, far from being evidence of a conspiracy hatched between co-perpetrators, is in fact a testament to the Duterte administration's respect for the rule of law and written proof of its intolerance for rotten apple police officers. As for the second official publication, which is supposed to substantiate the criminal plan, we turn to the 2016 annual report issued by the Philippine National Police. The statistics are quoted, with all respect, in a misleading fashion. The tables used by De La Rosa, and particularly the pie chart, show a remarkably low incidence of deaths in comparison to arrests and voluntary surrenders. Obviously, the misleading aspect of that is the prosecution's representation of the statistics, not De La Rosa's. So, coming to the 10th and final source of circumstantial evidence, supposedly supporting the mutually agreed nature of the criminal plan. And this is the fact that the extrajudicial killings, to quote the prosecution's words, followed the same patterns and modus operandi, with the perpetrators covering their tracks. But here, let me ask a question which begs an answer. If the Duterte administration was so barefaced as to openly declare its intent to kill drug users and pushers and celebrate this, as the prosecution argues, in official governmental publications, why would it encourage the perpetrators to go to such lengths to disguise such an intent? I mean, of course, anything's possible, but I'm just pointing out the internal contradiction in the prosecution's case theory. In any event, as they say in English, there is more than one way to skin a cat. And the differing types of modus operandi that we have encountered in the prosecution's 49 incidents of murder involve all conceivable modes of butchery, ranging from strangulation, suffocation, to stabbing and shooting. Now, assuming that the prosecution can overcome the hurdle of proving the existence of a common criminal plan, how has it shown that the so-called co-perpetrators coordinated between themselves to reach a mutual agreement to execute it? Well, it hasn't. All it can do is show a selection of comments made by Mr. Duterte's closest colleagues in government, and all of which take their rhetorical cue from him. The prosecution then artificially defines the intended individuals, the identified individuals, as a collective of co-perpetrators. Now, common law jurisdictions, such as the one I come from, are familiar with these issues in the context of the law of conspiracy. The federal rules in the United States, for example, allow the statements of co-perpetrators to be used as circumstantial evidence, one against the other, to establish the existence of a conspiracy, but require that these statements be made during and in furtherance thereof. Narrative venting, which is what all these supposed co-perpetrators did, the ones identified by the prosecution, does not further the criminal objective. In furtherance thereof means that the statement relied on must advance the objectives of the conspiracy, such as through reassurances, updates, or actions taken to avoid detection. Now, I do realize, Your Honours, that there isn't too much jurisprudence on this matter, but let us look at it logically. Where can one really draw the line if it is sufficient to infer a mutual agreement to execute a criminal plan if we rely only on the statements of the people in the vicinity of a criminally verbose suspect because of the same quality of verbosity it alleges? This is what could be called bootstrapping logic, building on limited information with the very same information in an attempt to validate that information or to create a structure there without. Put simply, the prosecution has advanced its cart before its horse. It has merely selected a number of individuals working alongside the former president who made similarly offensive comments and has then called them co-perpetrators. Instead of seeking evidence which might shed light on the interactions of these individuals between one and another, and construing a criminal conspiracy therefrom, should the evidence even support such a hypothesis, the prosecution has taken its preconceived and predetermined premise of a criminal plan and forcibly superimposed it on these individuals. The artifice of the prosecution's working methodology in conjuring up this criminal collusion becomes even more apparent if we examine the evidence emanating from the crime-based perpetrators themselves on a granular level, especially from the prosecution's own star witnesses, 2 of 3 of whom supposedly formed the hardcore of a more limited organization referred to earlier in my submissions. I'm trying to comply with redactions. P1, for example, a self-confessed murderer whose recruitment by the prosecution will be examined elsewhere, was asked about the common criminal plan of his associates up to 2017. And this is what he had to say. Every time somebody was at fault against the government of Rodrigo Duterte, we didn't bother to send them to prison. We would just kill them. That's PHL OTP 0001 2584 at lines 248 to 250. Okay, and that was the audio which I just quoted, and here we have the transcript. PHL OTP 0001 2376 hyphen R02, lines 248 to 250. So, having given you that quote from P1, I would say that as far as this witness was concerned, the common plan was not a refined policy of cleaning up the streets, but rather a killing frenzy of the political opposition. Obviously, no such policy existed, and no such policy is alleged. P3, whose evidence relates to the presidential period, describes a similar orgy of killing without rhyme and without reason, but not drug addicts, nor alleged criminals, but rather was so petrified of not meeting this quota of slaughter that he was randomly grabbing and killing just so that there would be something to report on TV for the one-time, big-time operation. Now, I ask you, how can P3 have been operating under a clear criminal direction to target drug users for murder, criminals for murder, when he states that on occasion he would perform so-called clean arrests? It's the prosecution's witness, P3. He's not clear when he's actually following their supposed criminal theory or when he's is. What are clean arrests? These are arrests subsequent to which the apprehended criminal would be handed over for a judicial process. And so with that, I believe, I have exhausted the first limb of the objective requirement for indirect co-perpetration and have shown conclusively that there was no mutually agreed common criminal plan. Madam President, there are 10 minutes to go. I will start with the concept of essential contribution, which is indeed the second limb that I want to talk about with respect to this mode of liability, which requires the prosecution to show objectively that Mr. Duterte himself made an essential contribution to the furtherance of this scheme of criminality, and what is more, that subjectively he was aware that he was making such a contribution. This is what us Latin-speaking lawyers, would call the sine qua non test. Or to put it another way, did these 49 murders, which the prosecution has identified, occur specifically because of Rodrigo Duterte's involvement? Or, to make the logic a whole lot simpler, would Rodrigo Duterte's withdrawal from this criminal scheme to target suspected criminals, as alleged by the prosecution, have led to the avoidance of these 78 deaths? Let us see where this test is set out in the Ali Koshaib trial judgment. Paragraph 796. And I'm going to quote the essential part for the purpose of the essential contribution. The accused must make an essential contribution without which the commission of the offence would not be possible. To hold an accused liable as a co-perpetrator under Article 25(3)(a) of the statute, it has to be established inter alia that he or she had control over the crime by virtue of his or her essential contribution to it and the resulting power to frustrate its commission. Well, here, I would like to show you the statistics pertaining to the rate of killings since the former president has left power and the responsibility for law and order has passed into the hands of President Ferdinand Marcos Jr. I rely on a report published by academics at the Third World Studies Center in the University of the Philippines in the context of what is called the Dahas Project. And trust me, the authors of this report, comprising weekly statistics on the first year of the Marcos administration from 2022 to 2023, are no great friends of the former president, Mr. Duterte. This report was even cited, I remember, in a Rappler article, but it's to be found on our list of evidence at PHL D36 0006 0001, pages 0006 to 0010. The report for the first year of the Marcos administration showed that out of 342 killings, 160 were at the hands of state agents. And the figures and the statistics just kept on rising, with the second year of the Marcos administration, 2023 to 2024, showing an increase in deaths at the hands of vigilantes, albeit a decrease in deaths at the hands of law enforcement officers, from 46.8% to 34%. Hardly a statistic to be proud of. So, with all the prosecutions, fancy bar charts, I'm pretty sure that if they were to recreate them for the period of 2 years after Duterte left power, they wouldn't have room left on their computer screen. The numbers would be so sky high. The conclusion is that there is no reason to believe that Duterte's disappearance from the political scene would have frustrated the ongoing incidents of murder at the hands of state agents or vigilantes. Clearly, I'm forced to ask myself whether anyone on the other side of this room has thought of investigating the Marcos regime and the related phenomenon and holding someone accountable. Why are my colleagues sitting to their right, the victims' representatives, not clamoring for accountability for those deaths? Or is it of no consequence now that Mr. Duterte is sitting in the ICC detention center? I've reached a natural break, Madam President, in my submission. With your permission, I would like to continue after lunch.
Judge Motok. Thank you very much, Mr. Kaufman. We will suspend the hearing now for 90 minutes to resume at 2 p.m. Thank you very much.